May I please, my lord?
1 second. Yes. My eyes are not very good, so I have to. Yes. Okay. Number?
My lord, I'm mentioning an unlisted matter, my lord, to be taken up on Monday.
Unlisted Monday?
Sorry, my lord. Pending matter to be taken up on Monday.
Okay.
Okay, my lord.
Sure. Listed on Monday?
Yeah, my lords, may I please mention a matter?
Yes.
My lords, this is item number 9 in my lord's cause list. This is regarding item 9. This is the section 37 under the Arbitration Act challenging a termination of a hydroelectric project. Am I audible, my lords?
Maybe it's from Delhi.
Am I audible, my lords?
Yes, yes. Now I can hear you.
My lords, this is an appeal under the Arbitration Act wherein we had challenged an interim order wherein regarding the termination of a hydroelectric project. The state government and us, the petitioner, have entered into settlement talks because they have in principle agreed to restore the project and revoke the termination. I'm requesting for an adjournment. My colleague on the other side is also here. It's a joint request. Since we are
Okay. On what ground you said? Yeah, the government and
the project has been in principle agreed to be restored. So they are agreeing to revoke the termination. There's a pending arbitration proceeding. Consent terms are being finalized there. My name is Aditya Swarup.
So you're a government advocate?
Yes, yes.
Yesterday also you appeared. I again forgot.
Yes.
T. Wangmu.
K. Wangmu.
Yes, T. Wangmu, government advocate for the state of Arunachal Pradesh. It has been stated by the learned counsel appearing for the appellant that the government has taken steps to
Restore the project.
restore
Agree to the
to restore the project, and as such, he has prayed for some time. And he has prayed for some time for.
I'm sorry, I'm not. My leadership is not audible to me. Any time in August would be sufficient. Convenient.
May I, my lord?
Very grateful.
May I, my lord?
Yes.
I beg to mention item number 18, my lord.
18.
18, my lord. Here I am for the respondent. Today I am filing my wakalat nama, Your Honor.
Acha. Notice of the issue?
Yes, recently we have received the notice. Therefore, Your Honor, I pray that this matter may be listed after 3 weeks.
Heard, Mr. Swarup. The counsel appearing for the respondent submits that he has received the notice and that he will file the wakalatnama during the course of the day.
Yes.
The prayer is allowed. List the matter after 3 weeks. The interim order, which was granted to continue.
Can the matter be listed after a week?
As prayed for by the counsel appearing for the petitioner, the matter to be listed after
A week, Your Lordship.
after a week.
Much obliged.
Lordship, I beg to mention item number 13. I am for private respondent number 2. On behalf of the arts owner, now leading counsel is busy with some urgent work. So
You've taken consent.
yeah.
Yes, I am appearing for the petition.
You are for the petitioner.
Petition.
Lordship, matter may be listed after a summer vacation.
After 3 weeks, on the prayer made by the counsel appearing for respondent number 2. which is also not objected by the council appearing for the petitioner, the matter to be listed after 3 weeks.
My lord, interim may be continue.
Interim passed earlier shall continue till the
May it please my lords, with my lordship's permission, may I mention item number 11, my leaderships?
the appeal.
Yes.
You are for tea tying.
Yes, lordship.
Okay.
On behalf of tea time.
You have informed the other side.
Yes, lordship.
Okay. Writing 24. The petition, the learned counsel appearing for the petitioner, prays for accommodation. He has prayed for some accommodation, full stop. He has stated that he had taken consent from the other side. List the matter after 3 weeks.
Obliged, lordship.
My lords, with your ladyship's permission, may I be permitted to mention item number 11, my lords?
11.
Please, my lords. My lords, I appear for the petitioner, my lords. I was not in a position, my lords, to travel for the hearing. The matter was listed in the cause list late last night. I traveled for Delhi for this matter, my lords. May I only request the matter may be listed on a fixed date, my lords, in July sometime, and it can be argued, my lords.
Responded, ma'am.
No objection.
Private, no objection.
How much time he wants, I could not
He said after vacation, madam.
vacation. So as prayed for by the council appearing for the petitioner, list the matter after 3 weeks.
My lord.
My lords, may I only request for a fixed date, my lords, because it gets a little difficult to plan and travel. My lords, the matter got listed late last night and I came to know it's difficult to travel from Delhi to Itanagar for the hearing.
Oh,
my lords.
you're from Delhi?
That's- Please, my
Okay.
lords, that's such short
Okay,
notice.
then after vacation, you can take it on, you can do it on 24th of July?
24th of July is convenient, my lords, if my learned colleague is also fine with it.
Okay, yes. List it on 24th of July.
Lords may continue the interim order, my lord, to the next date.
Yes.
Interim or earlier to continue till the next date.
Deeply obliged, my lords, deeply obliged.
May please, my lord. My lord, in item number 9, your lordship is directed for listing it after 3 weeks. But may I pray for a fixed date in the month of August?
Okay, give a date then in the month
Second,
of August.
second week.
Yes, 5th, 6th, whatever.
Yes.
6th of August.
6th of August. Item 9. All right.
Get it for me. It was in this file only, I don't know. Yes.
My lord, petitioner is agreed by my lord, the
Hmm.
summon and the so-called notice issued by the such authority, my lord, who has no jurisdiction, my lord.
Acha,
Therefore, my lord, I am agreed by this impugn, my lord, the series of my lord, the notice issued by the my lord, the so-called my lord, the apex customary code. There is no such my lord, the apex customary code of Arunachal Pradesh, my lord.
Acha.
So therefore, my lord, this is the impugn
So
order.
you are
may be stayed.
directed to attend the
Yes,
customary court.
yes, madam. There is no question. I am belongs to my lord, some other village, but this my lord, the authority, there is no authority such called the my lord, the customary apex customary court of Arunachal Pradesh, my lord. So my lord, by the issuing this. So therefore, my lord, this notice may be
Okay,
issued
notice will go.
and
You have challenged only this cause.
Yes, madam.
Notice. Only the
Only,
purpose
madam.
notice.
I am not required to appear before person who is not at all authority to my lord, decide everything, madam.
That has to be again examined.
Yes, madam.
Okay, heard Mr. T.
M. Kato,
M. Kato.
my lord.
Heard Mr. M. Kato for the petitioner. This petition is filed under Article 227 of the Constitution of India, read with Section 115 of the CPC for the residing customary judge of the Apex Customary Court of Arunachal Pradesh, by which the petitioner was directed to appear before the customary court,
Apex Customary Court, madam.
Apex Customary Court, were directed to appear before the Apex Customary Court and also to place the evidences by that all witnesses, also to place the evidences, and the said court has also has a full stop. The said presiding customary judge of Apex Customary Court had also said court, that's it's not a court, it's court of the said authority. You see this has no jurisdiction to pass such an order directing him to do the aforesaid. Issue notice to respondent number
My lord, all-
1 and 2.
My lord.
Huh?
Yes, ma'am.
1, 2 by registered post with AD as well as by usual process.
My lord, register for them.
Registered post. By registered post with AD, returnable within 3 weeks. That you know, returnable within 3 weeks. The petitioner to take steps for
Ma'am.
service of notice upon respondent number 1 and 2 within 3 days from today.
My lord.
Okay.
My lord, in the interim, madam. Interim protection. madam.
Oh, you are praying for an interim
Yes, ma'am.
protection.
Jurisdiction.
This is a customary thing, so you need not, we may not get it. I mean, there are some
My lord,
authority.
only as per the, my lord, the Civil Code Act, as well as the, my lord, the Assam Frontier Administration of Justice,
Yes.
only, my lord, the village authority of the particular village have the jurisdiction.
Mm.
There is no, that will be, my lord, the even where the petitioner is residing, and as well as the respondents are respondent complainant are residing within the same village, my lord. But this is a case where we are not residing there.
In the said village.
Yes, madam.
In the what village this is?
This is upper Dobam village, Karsinga, my lord. We are not residing.
Where do I, Upper Dobam?
Yes, ma'am.
Karsinga.
Karsinga.
You are not residing in that
No,
village. Neither the respondents.
Respondent is also not residing, my lord. How the complaint has been lodged there, my lord.
Marital issue.
My lord.
Some marital issue.
No, my lord, they are, the respondent number 1 is claiming properties. My lord, she is my divorced wife,
Acha.
made a complaint before the village authorities. Reside is not situated within that locality.
Right over your property in some other place.
Yes,
Which
ma'am.
is there in some other place.
Yes, ma'am. Property is,
They got involved.
yes, ma'am. My lord, my lord, my lord, challenge
Because
with
I'm not very used to this customary law, so.
Customary
make
court.
an application before the customary court.
Customary code of particular village where I'm residing, and the customary code of that, the property is located. They can have the jurisdiction. They can adjudicate. But if this property as well as both the parties are not residing within that jurisdiction. So therefore, without having jurisdiction, even I'm not required to be appear before the said.
Where have you made the pleadings
Madam.
on this? Oh, you have made some grounds.
Yes, madam. Para, my ground number 2, madam, page number 10. madam.
The council commissioner further states that neither the petitioner nor the respondent, 1. What about 2?
2 is the authority who issued impugn order, madam.
Acha. Oh, he is the one. Whether you need to make him a party?
That is because he is exercising beyond jurisdiction, in Quashing, somewhere, not as authorized by law, So therefore, I made him as one of the person, the respondent is on personal capacity, He does not have jurisdiction.
Authorities are not required, but if you allege some biasness on his part, okay.
Yes, he does not have jurisdiction, He cannot entertain,
Okay. Now, what do you say? That neither the petitioner nor respondent number 1 are resident of Upper Dobam village, Karsinga,
Karsingsa, madam.
Karsingsa,
Yes.
and as such, the presiding customary judge of Apex Customary Court of Arunachal Pradesh could not have issued show cause notices to the petitioner. As the same, as the said on a prima facie view, finds the submission and the law taken and the ground of law taken by the counsel for the petitioner as a correct proposition, and as such, you have filed an I or you have prayed here only? The state? Prayed here.
Yes, madam. Page number 14.
As such, pending disposal of the instant case, the operation of the Nelly show cause notice wide number NYEL/04/2025 dated 9/4/2025. There are 3 notices.
Yes, madam. Time and again we are giving reply. The recent one is last 25, 25, 25, madam.
25/4/2025 and 5/2025. There are 3 notices.
Petitioner is agreed by the order dated 6 of 2000 passed by the learned civil judge senior division. That is wherein my lordship, my money execution petition has been dismissed.
Oh, money execution. Oh,
Yes,
that
ma'am.
decree.
Degree.
And it
Lordship,
has
what is
been
the,
pending for long. Execution.
not pending for long. Lordship, what has happened in this, after getting the award, I had filed an money execution before the Learned Civil Justice Senior Division.
Mm.
And during the course of trial, the proceeding, the judge before the honorable court. As such, there was a civil warrant of arrest against him.
Acha, the judgment letter, yes, that warrant is in respect of some other case.
No, in respect of the same case.
Acha, okay.
And lordship, after more than 6 date, then the judgment debtor appeared before the court, saying that I'll pay within 2 months. So kindly allow me some more time. So the honorable court had given him 2 months time. Then after next that he neither appeared nor his counsel came and said he's not cooperating with the matter. As such, lordship, the civil warrant of arrest was reviewed. But lordship, in meantime, there was an order from the Guwahati High Court that which I have annexed lordship. Kindly
Has
see,
to complete it within 6 months.
yes, lordship. Taking into this matter, lordship, the next day, the civil division has said, since you have not provided the judgment debtor property, the matter is dismissed.
Acha.
So, as per when it is
Because of the time frame.
not because of the time frame, lordship. He said that is the impugn order. May I see, Lord, take it to page 18. Which
Yes.
page 18?
Just read it.
The paragraph 3, lordship, the learned counsel of the DH has submitted.
Judgment letter is absent.
Yes,
okay.
ma'am.
Learned
Judgment-
counsel for
the DH
decree holder.
has submitted that he has failed to locate any property of JD within a jurisdiction of this court. Further, it is seen that the instant money is pending before this court since 2023. But till then, no property of JD has been located within the jurisdiction of this court. It is noted by this court that limitation period to file execution as per article so and so is 12 years from date of decree. Accordingly, instant money is dismissed for default with liberty to file afresh on location of JD within the jurisdiction of this court, if any, provided the same is filed within the limitation period. With this order, lordship, with this impugn order, since lordship, there is all warrant of arrest against the judgment debtor. So that ought to have been continued, lordship. And as per lordship's CPC, it is the judgment debtor who has to provide his property. It's not the degree holder who has to look out for this property. Lord.
Where is the provision for that? That it is not for the decree holder to find, but the judgment debtor has to provide.
Lordship, I've clearly mentioned in my may I take lordship to my page 11 order. Order 12, rule 41.
Page 11.
Yes, page 11, G lordship. For the learned failed to appreciate the mandate of order 21, rule 41, which case upon the judgment debtor to disclose its assets and property fairly upon the court to execute the degree passed by the court and in non-compliance of the order of court, the degree holder is not liable to be punished as far. So lordship, since when it comes to the high court also, a contempt case, when a contempt is derived contempt, it's between the court and the contempt. The petition has nothing to do with it. The same case, it's when an execution is filed, it's between the judgment debtor and the court.
He has to disclose. He
Yes,
has to
ma'am.
disclose his
And
assets
also in our case, the judgment debtor has not appeared before the honorable court after getting since the degree was passed in a lok adalat, lordship. So the very purpose of getting the degree become futile, lordship.
Now, in case he cannot disclose his assets, then in case what happens? Just show me that CPC once. This is order 21, rule 14. Whether the owners goes to the degree holder.
Yes, look.
Order 20.
Attachment of property, lordship. Lordship, in our case, since there is already a civil warrant of arrest against the judgment debtor.
Rule, once again, rule 41.
41, order 21/41.
Yes. 41.
Attachment of property.
Examination of attachment of property.
Yes, Lordship. May I read, sir?
Examination of judgment debtor. Where will decrease will payment allow? Money will decrease. So it is for the judgment debtor to show.
Yes, Lordship. Because the degree
And if he
holder.
cannot show also, he will be put inside the prison.
Yes, Lordship. Since in our case, Lordship, there is already a civil warrant of arrest against
Hmm.
against
Against the
the judgment
judgment
debtor.
debtor. Okay, it is understood that the warrant of arrest has been issued against him
Lord,
to
sir.
keep, that will be in compliance with 41 Rule 3,
Yes, Lord.
right?
Hmm.
Rule 41 Sub Rule 3.
Yes, Lordship.
So if after that, what happens?
After that, Lordship, since Lordship, here in our the judgment debtor is a public servant. He's employed as in a government service. So his salary will be deducted, Lordship. He has to show his all means of property, whether he can pay or even if
Salary deduction, even in what those compensation need, that maintenance cases. I think Supreme Court has said salary need not be deducted, something more.
Lordship, whether he has to file before this honorable court, whether he has any means to pay the.
Anyway, I'll admit this, I'll issue notice, but then this one interim will be considered after they appear.
Lordship, here kindly may appreciate here in even in the our money execution, he has not appeared before, Lordship.
He has not appeared,
Yeah.
so warrant was issued. He must be inside now or what?
No,
He's
no, Lordship, he has not been arrested. He's
Absconding.
He's absconding or Lordship. He has been under. Was
So anyway, I'll issue notice and the interim
Lordship,
to be considered
Lordship,
on
kindly-
their appearance.
Lordship, since it's I have been awarded in the year 2023, Lordship. So instead of keeping pending, Lordship, this matter can also is an interim, Lordship.
Because the court has specifically stated that the decree holder has failed to locate any property. Right. Of course, the duty is on the judgment
Yes,
debtor.
Lordship.
But after he is like, and those things are issued, what happens? Like you said, salary to be deducted and all, that part I'm not very sure. So
Lord-
let the other party come.
Lordship,
On the next
I doubt, Lordship, even he'll not appear before this honorable court. Since Lordship, when there was even a civil or
Then we
warrant.
will take, then we can pass order ex parte. There is no issue. But let us give them one chance so that they say their own part. Okay. He might not be having any property. Let's see. Okay. Heard, Mr.
Lordship, I have an interim in this matter. Lordship, in the interim, let the.
Then that is what I'm saying. As far as issuing notice, no problem.
No.
But then interim will be considered after the opposite side appears. And if they do not appear, then ex parte, then we will. Mr. It's okay because things are not very clear. So I'm not passing the interim order. Heard Mr. Vijay Jemo.
Yes, Lordship.
Heard Mr. Vijay Jemo appearing for the petitioner. Learned counsel appearing for the petitioner. The instant in the instant what did you say? Civil revision petition.
Yes, Lord.
In the instant civil revision petition, the petitioner has challenged the order dated 6/5 has challenged order dated 6/5/2025 by Civil Judge Senior Division at UPIA, Court of Civil Judge Senior Division at UPIA, Popompare, Arunachal Pradesh, in money execution case number 12 of 2023, by which the money execution case was dismissed for default with liberty to file afresh after locating the property of the judgment debtor within the jurisdiction of the said court. The learned court, by the said order, had observed that the decree holder had failed to locate any property of the judgment debtor within the jurisdiction court, and that the money execution case has been pending since 2023. And the property has not been located till date. The counsel appearing for the petitioner states that it is the duty of the judgment debtor to which paragraph you say G, right?
G, Lord, it's
It is the duty of the, yeah.
it's onus upon the judgment debtor to disclose its assets and property. Page 11, Lordship.
Page 11. And it is the judgment debtor who has to disclose his assets and liabilities fairly before the court for execution of the decree, And it is not the duty of the decree holder to show the properties, to locate the properties of the judgment debtor as held by the Court of Civil Judge, Senior Division at UPR. Full stop, para. Issue notice, returnable by 2 weeks.
Yes, Lord.
The petitioner to take steps for service of notice upon respondent number 1. Let only one come. The authority need not be given issue. Notice now.
Not made the private.
Oh, in the other case it was.
Yeah.
Okay, I got confused. Okay, so we'll take steps for service of notice upon the sole respondent within 3 days from today. List the matter after 2 weeks.
Lordship, it may be observed that on the next day the interim may be heard.
The interim order shall be considered on the next date. On appearance, don't write. On the next date. Even if they do not appear, it will
Yes.
be considered.
Deeply obliged.
Lordship, this is an anticipatory bill in connection to Think PS case number 2 of 2025. Under charges 318 clause 4, 316 subclause 2 and 35 of BNS.
What are these sections? BNSS, I cannot. What are the IPC sections?
This is for
318 is?
cheating and 316 is for criminal breach of trust.
Or criminal breach of trust. 318 is also that.
Cheating.
Cheating. Okay, 420. So 318, 316 and what is 35? Common object.
Common intention.
Intention.
Lordship may come to page 13 the FIR. May I read the FIR?
Yes.
With humble submission, I beg to inform you that one Shri Dheeraj Pau, MD HDD Service Private Limited, Chandan Nagar.
What is the petitioner's name?
Dheeraj Pau.
Dheeraj Rao. Okay.
Dheeraj Pau. And his associate partner Shri Prashant Kumar so and so has cheated me by engaging me, my man machines at the site, construction and upgradation of detailed making of so and so kilometer design and change in the state of Arunachal Pradesh to 2 land under project Brahmag in the state of Arunachal Pradesh, Upper Siang district. I have completed 468 meters of work and the bill of the said quantity amounting to 46,80,000 and 80,000 paid to landowners for valley side mud dumping has been submitted to MD HHD, that is Dheeraj Pao, but they never paid any penny for the said work and are absconding since then. Lordship, the prima facie in the FIR discloses civil disputes arising out of a contract work. And there is no allegation in the FIR that from the very inception, the applicant had the criminal intention to cheat. At the best, the allegation just reveals the breach of contract, Lordship.
What is the work? Construction and upgradation of?
It is a place, Lordship, in Upper Singh.
Acha, acha. Of DTDM Migging, that's a
Yes.
place.
Yes.
Design and
It is for road.
chainage. What is chainage? In the state of Arunachal Pradesh to 2-lane. So they are like widening the road.
Yes.
Acha.
Lordship, this is purely out of a civil dispute, Lordship, and the Supreme Court has time and again deprecated the practice of giving criminal color to civil dispute, Lordship, and the use of criminal law machinery for settling civil dispute, Lordship. Lordship, I may be allowed to place a judgment.
Any amount paid to the workers?
Not yet.
Nothing.
No. Actually, the Lordship, the complainant, he just worked for 1 month and he was on run, Lordship.
Only 1 month he worked.
Yes, and the
But then the amount that was accumulated was 46,80,000.
yes.
Or what? This 46,80,000 is paid to the landowners, not them.
No, 46 was the bill that the complainant has made for the work he has done. And it, for 468 meters of work that he has done.
And 80,000 was
It-
paid to.
Yes,
landowner.
it was paid to the landowners for land dumping, mud dumping. Lordship, this is
Illicit deception is not writ large in the FIR, but what is the next page that you notice? This is 41A notice have been served on you, so why are you apprehending arrest?
no, Lordship. To think actually to think it is in Upper Singh district, which is nearing to China border. It is in very interior. Due to the monsoon weather, there has been many floods and blockage, so the applicant was not able to go. Lordship. But
No,
he
why
said
are
it.
you apprehending arrest? 41A is not meant for arrest, it is only.
No, Lordship, actually, the dispute is solely a civil dispute, but the applicant has framed this as in criminal color. So the applicant just want the protection may be given, Lordship.
So what do you say, Ms. Jenny?
Your Lordship, in fact, the accused here is a habitual offender. Your Lordship.
Acha.
Even on earlier occasion, there was 2 FIRs, out of which even in one of the cases, he has introduced himself as a MD of certain firms, and he collected the money and did the same whatsoever is happening in this, even in the instance case. I'll just like to place these 2 orders, Your Lordship.
So if he is an habitual offender, then it will be difficult.
Lordship, even though he is he may be an habitual offender, but he has never been convicted, and no charge sheet has been filed against him. And
No.
all the cases are of civil dispute, Lordship. It cannot be a factor to disentitle him of the right to bail, Lordship.
Your Lordship, in both these cases, charge sheet has been filed, Your Lordship. If Your Lordship will see paragraph 3, I'll just
Paragraph-
give the brief of the case, Your Lordship.
Acha, in Hitesh Pao, which is paragraph 9.
In Hitesh Pao, it's paragraph 3, Your Lordship. I'll just show the modus operandi, Your Lordship. Paragraph 3. The case of the petitioner is one Sri Rimna Padu lodged a written FIR before the OC Chimpu against accused Dheeraj Pao for fraud and cheating, alleged that the accused Pao himself introduced himself as director of MS Estate Private Limited and had approached him for financial assistance to carry out installation of Airtel tower work in the state of AP. Thereupon, he provided finance for said work according to the terms and conditions of the memorandum of understanding executed by them on so and so. Accordingly, he arranged funds amounting to 92 lakhs only and deposited it in the account of the accused. However, the accused has failed to fulfill his commitment and has not refunded the amount given to him. It is further alleged that the accused is evading communication and has shown no intention to return the money, indicating a clear intention to commit fraud. It is also alleged that now it has come to the light that the accused is not the director of Messrs. Rhodes Estate Private Limited, basing of the So even in this case, Your Lordship, this is also of the same, because in this FIR also he has a similar. Next case, Your Lordship will see.
In this Dheeraj Paul,
Yes.
there,
Dheeraj Paul, Your Lordship will see that in this case, interim was granted and he was directed to appear. He did not appear, Your Lordship. If I may take Your Lordship to the last page of the order, Your Lordship. Here are the cases where he is involved. The accused petitioner for commission of the eligible. The record also reveals that accused person is a habitual offender involving multiple cases, Diomali PS so and so. Your Lordship will see under 406, 420. Chimpu PS case 9 so and so under section 420C and CR case number so and so under 138 and 142 NIC apart from the present case under 420, Your Lordship. He is a habitual, Your Lordship.
so what I do is I'll call for the case diary, not a case for interim. And if I write all this, then it will have an effect on your interim on the next day.
Lordship, I pray that interim may be granted as the.
That is what I'm saying, not a case for interim, because he has been representing himself as the MD of so many company and he has taken money. So not a case of interim as such, but I'll call for the case diary and I'll simply call for the case diary. Otherwise, if I write all this, then he'll be.
The applicant is ready to cooperate as do think
This is okay. This he will have to cooperate. That is okay. But since it is seen from all this that he has been doing this off and on, and he has been accumulating money out of that. So let the case diary come, and the next date it will be come.
Yes, Your Lordship.
Okay. Third, Miss So and so, and Miss Jeannie. Then additional public prosecutor. I'll not write anything on this. Call for the case diary. When can you bring
On
it?
30, Your Lordship.
On case diary to call for the case diary. List the matter on 30th.
Yes,
On 30th of July this month, June 2025.
Deep.
There also there are materials showing.
Your Lordship, since in the FIR it has been stated that bill was submitted in the account of the petitioner in person in item number 4, Your Lordship. It has to be very. One notice was also given to him, Your Lordship. He has not appeared till date, Your Lordship.
But then there is no such thing as habitual offender and all.
Not specifically, Your Lordship, because only the Dheeraj Pao had come for bail on this before this honorable court, Your Lordship.
Show me the FIR there.
Same, Your Lordship.
Same page. 30.
Page number, Your Lordship, will find in
So
page
the
number.
Lordship, the applicant herein is the associate partner of Dheeraj Pao.
Acha. Oh,
sir.
he is the associate partner.
Yes.
Prashant
So if he is an associate, Your Lordship,
and
if
his
the
associate partner. So they both are doing it together.
Yes.
So let's call for the case diary. It's okay. I thought he is some other person and involved in some other case.
deeply aware.
No, please, madam. Madam, this is an application under 528 for Quashing. Madam, will find the FIR at page
Posting
7.
of FIR
FIR in the charge sheet.
and the charge.
FIR is at page 17, madam. And the charge
17.
17. And the charge sheet starts from 19, page 19.
There is no ejahar. Down in the copy that the informant gives, the information
No.
that the informant gives.
No, my lord.
No.
No. My lord, once Pertin, assistant engineer, PWD gains a division.
Okay, let
Yes.
me see the charge sheet. The story will be there. There are so many accused persons here.
No.
There are lordship because one complainant, one accused lordship, this is engineer and other co-accusers are there, Lordship,
That
who is
is what I have seen
associated
in
with
the
him. Yes.
charge sheet. One is Ajay Bin, and this is in respect of whom?
Tenzing,
Tenzing Zerang.
Tenzing Zera.
Tenzing Zerang is one.
Yes, madam. 1, 2.
Accused person not charge sheeted. Oh, cha. Ajay Bin and all are not charge sheeted.
Lordship, charge sheet, Lordship, other co-accused was also there, Lordship. Amin Hussain and this Sahid Ali, Minjum Sora, Ajay Bin, Tribhuvan Sahani, Lordship.
Okay, read the charge sheet, not a very long one. Yes, page number 25.
25, 26, Lordship. 26 is the Lordship, where Lordship, there.
Let
private
me
case
finish
is
the petition. You are PP.
Yes, Lordship,
Oh,
additional PP.
I'll come to it. You
Well,
proceed
the-
with the story. Read the charge sheet, page number 25, paragraph 1.
The procedural story of the case is in brief that on 4/10/2023 at 800 hours, a written complaint was received from one Sri Tayom Pertin, A. Gilling Subdivision, APPWD, so and so, to the effect that on the night of 2nd September 2023, some unknown miscreants stolen a malfunctioned road roller worn by the PWD department, Padu to Katan Road. On receipt of the written complaint, a case white MRG PS case number 07/2023 under section 379 IPC was registered, and I take up the case for further investigation. During the investigation, the informant of the case, namely Sri Tayam Pertin, was examined and recorded. Actually, it has to be his, it is her.
Oh, okay.
Her statement under section 1 so and so, in which he corroborated the FIR. Besides that visited the PO, a photograph of the damaged road roller was taken and drawn the sketch map of the PO and examined the villagers of Padu village, in which they revealed that on 2/9/2023, one local youth.
What he visited the PO and next day photographs of damaged road roller.
Yes, my lord.
And this is the one which is stated to have been stolen.
Yes, my lord.
But then it's there in the at the place of offer.
No, my lord. I'm a young guy, my lord, of 21. At that point of time, I was 21 years old. So I was dealing with the petty businesses like buying scraps and collecting scrap and selling it to the scrap dealers. So it's road loader. It was malfunctioning. It was there for decades, man.
There was a malfunctioning.
Yes, it was a dilapidated. It was in a dilapidated state, my lord. So I did not take the entire road loader, my lord. But I took some part of it, and sold it to the
Scrap
dealers, my lord.
dealers.
Scrap dealers.
One local youth.
One local youth brought few laborers and cut the abandoned road loader that into small pieces with the help of an oxygen cutter and took them in a mini truck. Accordingly, the CCTV footages of Smart City Pasig installed at tree junction near Forest Check Gate. However, all such efforts become futile. In further course of investigation, all the scrap dealers go down of Pasigat were checked and recovered the stolen parts of the road loader from the scrap go down. One of Sri Amin Hussain. Subsequently, the stolen parts and his tools used for cutting road loader were oxygen cylinder, LPG cylinder, etc. The mini truck bearing registration number so and so, and brought back at PS Mayang. However, the parts of the road loader could not be brought back at PS Mayang due to its heaviness. They were also who cut the road loader were taken into custody and arrested and brought back at PS Mayang for interrogation. During interrogation, the laborers revealed that they were working under one Sri Amin Hussain, who is currently out of station for his medical health treatment at Guwahati, Assam. Further, they revealed that one local youth took them to the site where the road loader was parked, and as per the direction of him and Sri Amin Hussain, they cut the road loader into small pieces so that it can be transported to Pasigat in mini truck. Accordingly, Amin was contacted over telephone, in which he informed that currently he is undergoing a treatment at Guwahati Downtown Hospital, and as and when he arrived at Pasigat, he will PS. Further, he informed that one Sri Tenzing Zerang, he is the petitioner here in Manila, came to his house and offered him to install one government option road loader as earlier Sri Amin Hussain has brought few government auction vehicles from him. As such, they made a deal finally in good faith and paid rupees 1,25,000.
Oh, acha, he said that what, one Tenzing Zerang, this is
Yes.
the petitioner.
Yes, madam.
Came to his home and offered him to sell the same.
Yes, madam.
Okay. As in earlier, so and so, okay.
Only through Punjab National Bank, further Sri Tenzing Zerang informed to him that the auction paper were to be handed over to him later on. Accordingly, a requisition was submitted to the branch manager, Punjab National Bank, Pasigat, under section so and so, to furnish the account statement of Sri Amin Hussain. After furnishing of account statement, it was scrutinized and found that rupees 1,25,000 were transferred in the account of one Sri so and so Tenzing Zerang SBI account. Subsequently, another requisition under section 91 of CRPC was submitted to the SBI chief manager Pasigat to furnish the KYC details and account statement of the Tenzing Zerang. Accordingly, the KYC and account statement was furnished. After residential address of Tenzing Zerang, a notice under section 41A CRPC was served to appear before the IO of the case at Mariang PS. The alleged accused person, Tenzing Zerang, appeared at PS Mariang and deposed his statement in which he revealed that he took the parts in government vehicle auction and sold them to the scrapped dealers in Pasigat. The roll which I sold to Sri Amin Hussain was abandoned by PWD department since 15 to 20 years at WRC field at Padu village. Further, he admitted that he had stolen the roller, sold the roller to Sri Amin Hussain and disguised him to hand over the auction papers of roller later on as he is in urgent need of money. Further, he gave assurance to cooperate with the investigation of the instant case as such he was allowed to go from PS. The stolen parts of the roller released on Jimma to Sri Rokom Tang, Junior Engineer PW so and so, and dated 13/9 Amin presented himself before PS Mariang along with anticipatory bail issued by District and Session Judge Pasigat White, AB number so and so. Accordingly, he was examined and recorded his statement under section 161. Moreover, he produced auction papers, documents of government vehicle which he had earlier bought from Sri Tenzing Zerang as accomplice. As compliance to the court order, he was arrested and released on bail. The investigation revealed that alleged accused person, Sri Tenzing, has illegally sold the government machinery roller to Amin Hussain, which he bought in good faith.
Amin Hussain, Sabir, they are exonerated, right, from their liabilities.
Which brought to good faith cause him wrongful loss. Further, the laborers engaged in cutting the roller were ignorant. As such, the Honorable Court is prayed to exonerate Sri Amin Gao and Sri Asabet Ali, Sri Minjum Sora, Sri Ajay bin Tribuwan Sahani from their liabilities of bond executed by them. Under the facts and circumstances, a preliminary case under section 379 IPC found well established against the alleged accused person, Sri Tenzing.
Okay. So
My lord,
what
here,
is-
what happened, my lord, I was 21 years old, my lord. I was 21 years old at that point of time, my lord. Now, since I was dealing with this petty business of collecting scraps and selling it to the dealers, my lord. So this was a rot loader which was abandoned for 15 to 20 years.
Had it been abandoned, this would not have been taken by the officer on Jimma.
Therefore, my lord, and then thereafter, my lord, on after filing the charge sheet, my lord, on 11/12/2024, my lord, if my lord turns to page 43, my lord.
This is a government vehicle. So,
That is there, my lord.
and then it cannot be said to be abandoned. I mean, they would have auctioned and all. That is not done.
That is there, my lord.
So
I do admit
we
to that.
cannot say that it was just lying there.
It
And
was
they
lying.
kind of stole it.
But then, my lord, after the recovery, in fact, in the charge sheet, it has been said that it was recovered by the police, my lord.
Ah, it
But
was
in fact, the fact remains that, my lord, it was me after knowing that it was an FIR has been filed, my lord. I was the one who brought it back and gave it to the informant, my lord. And it has been
Where is that? No, they had they got those. The police got those parts
my lord.
in the Amin Hussain shop, or where? Amin Hussain shop.
Yes, but sees the deed of settlement between the informant complainant
There's a settlement also.
Yes, my lord.
Where?
Page 43, my lord.
43.
If my lord turns to page,
Hmm.
now my lord, here the first party
Teom Patin is the informant.
informant, the APWD, and second party is the accused person, my lord. If my lord turns to the next page, my lord, page
Teom
44.
Patin. Written number of Teom Patin. Who is Teom Patin? He's a government official.
Yes, my lord.
Acha. So, Teom Patin and Tenzing Jeran.
Yes, my lord. If my lord turn to page 44, my lord.
44.
Yes, the second parameter. May I read it, my lord? Whereas the second party has approached the first party to exhibit his remorse and tender his unconditional apology, further explain the interfering circumstances at the relevant period, which was carried out in anticipation for the fact that the second party was involved in the business of buying auction machines and vehicles of various government departments. Accordingly, the first party, considering the remorse exhibit apology tendered by the second party, as well as on account of leading to recovery of the stolen property, has forgiven and decided to amicably settle the matter between them.
Hope this settlement is not through other means.
No, no,
Because see,
no, my lord. My lord, this is
unconditional apology and that the things were recovered. That cannot be a ground for settlement.
but then my lord will kindly appreciate the fact that, my lord, it was just like malfunction for so many years, just because it was not auctioned, my lord. And it was not even the government, they were not using it also, my lord.
They were not, because
Only
it's
the-
in a dilapidated condition.
Yes.
Huh.
And in the next page, my lord, the second party says that he doesn't want to pursue.
Huh.
Now, if down below, nowhere in the deed executed written so and so, the terms and conditions, my lord, at page 45, my lord, clause 1, my lord, that both the parties have amicably settled their differences and misunderstanding. That the first party does not have any grievances against the second party in relation to the Mariang PS case number so and so. In that the first party wants to put an end to the above mentioned case, as the second party is tendered an unconditional apology.
Executed when?
Executed on 11/12/2024, my lord.
11?
12/2024.
11, 12, 24.
Before
you have
the,
NXP 161 statement also, no? I have seen.
yes, ma'am.
What charge sheet you have read, but then. Then what else?
Page 45, my lord.
Mm-hmm.
The first party wants to put an end to the aforesaid case, as the second has tendered an unconditional apology for his action, which has caused his inconvenience, and is repentant for the whole episode. Further, also the stolen properties have already been recovered by the informant authority. That the first party undertakes and assures that he shall not pursue the Mariang PS case number so and so against the second party, and he has no objection if any competent court exonerates or discharges or accuses the second party from his liabilities in the above case. That in view of the mutual understanding of the parties above named, they have decided their misunderstanding amicably now and forever to live peacefully with the deed of amicable settlement in connection with the above noted case, and if the court desires, the party have further agreed to use this deed of amicable settlement as a piece of evidence for compounding and quashing or withdrawing or getting acquittal or dismissal of the
Okay,
effort.
okay. That I can make.
So and so.
It is only under 379.
Yes, my lord.
Acha, you are appearing for both the parties.
No, my lord. I'm appearing only for the petitioner, my lord.
Time party is respond number 2.
Yes, my lord.
And
Because he's the informant now.
no, but what about the 161? I mean, just go through once.
Once
What did the informant say? Page number 28, right?
Yes, ma'am. Married.
No, it's okay. I'll just go through once. think these are all workers, right?
Yes, madam. My statement can be found at page 33.
Mm.
Okay.
What do you say?
Yeah, lordship, first of all, lordship, this FIR lordship lodged by the complainant as a capacity of assistant engineer lordship and subject thereby lordship the theft of the road roller from the PWD department.
Mm.
Lordship, that means lordship, this is not a personal. Lordship, next is lordship in the statement of the complainant lordship, which is 161 in the page 28. It hereby lordship reflected the road poster in question was parked at Padu in WRC village field along Padu to Katan Road, and it was under the supervision of PWD. It is clearly mentioned that it is under the supervision of PWD lordship. And lordship, whereas the accused lordship, petitioner lordship statement in page 33, his statement under 161 lordship, here it is stated that as per his statement, may lordship, that lordship owned by the police, I've stated that on 29 August 23 at around 10:30 hours, I hired a friend's car belonged to one this as my was not available and went to Sri, that is other person lordship, house at Pasigat near hospital for assessing negotiating price of road loader. I told him that I have abandoned road loader auction by PWD for sale. That is contradiction of the statement of the complainant lordship. Here lordship is statement
on auction.
lordship. As well lordship. Now his statement like that he is auctioned by PWD for sale lordship. But in the complainant statement that it was under supervision of PWD, there nowhere it was stated that it was for the auction for the sale. That is the contradiction part, lordship. And
My lord,
Let her finish.
yes, lordship. On lordship, moreover, lordship, if they have come before this honorable court under 580/28 in for the joint petition lordship, they have come settlement lordship, but this petition is not as a joint petition. Their petition lordship, they have lordship made the respondent number 2 lordship, complainant is number 2. That means this is not a joint petition. So thereby lordship, the settlement lordship thereby not attracted lordship in this petition. And moreover, lordship, this is government property. It cannot be lordship settled lordship as a non-property. That is my point, lordship. So lordship, it is clearly lordship statement also contradicting with each other. It is fit for case for the trial lordship.
What about notice on respond number 2? He need not, he.
They have made party respond number 2 lordship as complaint as
Because
respond number
if you
2.
go by the settlement, then I'll have to hear him.
Yes, that can be, madam. Well, that's why, my lord, I have made him the party, madam. My lord, what I'm happy about, I'm saying that I'm not denying that, my lord, it was that vehicle was not auctioned, my lord. I say this, it was not auctioned. It was lying there in a dilapidated state for the last 15 to 20 years, my lord. And it is under the supervision of PWD.
But before police, you said that it is auction.
No,
for
no,
sale.
not before police, my lord. Before the one, whom I was,
No, this 161 statement that
Yes,
she had
lordship.
just placed.
no,
Page number-
I used to buy auction machineries from other.
That is no.
That was the end.
But 33, your statement before the police, you said that it was The road roller was auctioned by PWD for sale.
Whatsoever, my lord, now, since there is.
Let the notice go to respond number
My
2.
lord.
Yes,
And
Lordship.
then if I have to act on the settlement, then I need to hear him.
My lord.
And Lordship, yes, Lordship. Because charge sheet already been filed, whether it is produced before the court or not, we have also don't know. So I have to take instruction part also, Lordship.
At least, my lord, till then, my lord, at least, if can copy maybe call for my lord.
Huh?
I have an interim prayer, my lord. Till the return will take at least, my lord.
Lordship, already charge sheeted, Lordship, then Lordship, at the use of
But
interim
even
prayer,
if
Lordship.
it goes on, my lord, if it will be an abuse of the procedure, my lord. But once there is a settlement, it has been executed before the
Lordship,
law.
settlement, Lordship, petition is not also, joint petition is not there, Lordship. Petition also.
Yes,
Yeah.
let the proceeding be stayed.
Well,
Lordship, then what the use of Lordship, then the other party will appear, Lordship, if petition is before his appearance is stay, Lordship.
let him
On the
come.
next day, Lordship, let the other party come, Lordship. Lordship can see, Lordship. They have come for the settlement, and whereas this petition is not a joint petition also, Lordship.
And so
Yes,
let the
Lordship,
other
then
party
other
come.
party may call for Lordship. Notice may issue, Lordship, at this point of time, Lordship. Only notice may go, Lordship.
My lord, I am harping on the settlement deed which was executed, my lord.
But certain cases cannot be settled. That is a.
My lord, that
Had
I
it been a private property, he
Yes, Lordship,
stole
then
it,
it won't be
okay.
any problem.
that I
But
understand.
then this is a government property, and then anybody will go and sell the dilapidated, those damaged vehicle
Still, but
to the scrap
my interim
dealers.
prayer, my lord. At least, as my lord has rightly said, my lord, you have to hear the second, the respondent, my lord. Till the respondent appears, my lord.
Let me dictate. I'll think. Heard, Mr. I'll think over. Let me dictate. Heard, Mr.
Opada, my lord.
This is my chicken. Heard, Mr. O. Pada.
My lord.
Mr. O. Pada for appearing for the petitioner. And what is your name? You are
Lordship, El Hage. El Hage.
Lakshmi Hage.
Yes, Lakshmi Hage, Lordship.
Lakshmi Hage, the learned additional public prosecutor for the state of Arunachal Pradesh. This is an application filed for quashing of the FIR as well as the charge sheet. Quashing of the FIR dated 5/9/2023 as well as the charge sheet CS number 8 of 2024 dated 5/9/2024. No, don't write Mr. Rupaga. The prosecution story, as is revealed from the FIR, is on 2nd of September 2023, some unknown miscreant stole a malfunctioned road roller owned by PWD department, Mariang division. Full stop. And the said incident was reported by the complainant, who is a government official. And on the basis of the said complaint, the MRG PS case number 7/2023 under section 379 IPC was registered. During the investigation, that one local youth brought few laborers and had cut the abandoned road roller, cut the alleged abandoned road roller into small pieces with the help of oxygen cutter and took them in a mini truck. In the course of the investigation, all scrap dealers, the what do you say, the shops or what, the outlets, the godowns, right? The godowns of all the scrap dealers were checked. And finally, in one of the said godown owned by Shri Amin Hussain, the stolen parts of the roller were recovered. The tools used for cutting the said road roller and the mini truck were also recovered and were brought back to the police station. The police took in custody the laborers who had the road roller for investigation. During investigation, the laborers revealed that they work under Shri Amin Hussain and further stated that one local youth took them to the site where the road roller was parked, and as per the direction of that youth and they cut the road roller into small pieces. The police on inquiry the police questioned Shri Amin Hussain and found out that the petitioner came to his home and offered him to sail the said road roller. Shri Amin Hussain further stated to the police that they were involved earlier also in the said business. He, on good faith, without the auction paper being handed over to him, entered into an agreement with the petitioner and the required, no, not gave him, without being, he bought the parts of the road roller sold by the petitioner. The police, on completion of the investigation, submitted the charge sheet as mentioned above. The learned counsel for the petitioner submits apart from the settlement, what did you say on the merit of the case on your submission?
Madam.
What is your submission as far as the quashing of the case apart from the settlement?
Since my lord, the matter has been immediately settled, my lord, even if
And not settlement, other part
other part I don't
for
have-
quashing?
I'm a very young person, my lord. I was 21 years old at that point of time, my lord. Now I'm hardly 23 years old, my lord.
And
And since I was dealing in scale-ups, my lord, and since it was there for the last 15 to 20 years, my lord, in a dilapidated state, my lord. So,
And the 15 to 20 years, the vehicle was abandoned.
yes, my lord. Yes.
15 to 20 years.
Yes, ma'am.
Okay, so and so states, submits before this court that the petitioner is a young boy in his 20s, and that he did not understand the consequences of selling an abandoned road roller which was lying in a dilapidated state, as to the fact that the roller '61 that it is auction for sale and all.
Yes,
Right?
ma'am.
Anyway, he did not understand the consequence, and then the learned counsel had also submitted that a settlement was entered into, an amicable settlement was entered into between the informant and the petitioner, which is annexed as Annexure 3 at page number 43 of the petition. Wherein both the parties is stated to have settled their differences and misunderstanding. And that the desires to put an end to the instant case on the tender, on the apology tendered, unconditional apology, on the unconditional apology tendered by the petitioner. Stop there. On the other hand, Srimati Lakshmi Hage, the learned additional public prosecutor for the state of Arunachal Pradesh, submits that the instant petition is not a joint petition, both by the petitioner as well as the informant, and that the informant was made a respondent, being respondent number 2 in the instant petition. And that the settlement cannot be taken into consideration for quashing of the instant case. She also placed the 161 statement of the petitioner, who had stated before the investigating officer that the said road roller.
No, my lord. I have not firstly stated, my lord. I have told, I mean,
Yes.
that is the issue, my lord. Not
told before the investigating officer that he, while negotiating while assessing and negotiating the price of the road roller with Shri Amin Hussain, he told him that he has a abandoned road roller auctioned by PWD for sale. Full stop.
But in the complainant statement is contradiction, lordship. The complainant statement also there, lordship, in the page 28, lordship. Whereby, lordship, that road loader in question was parked, lordship, and it was under the supervision of PWD. I don't know where it was mentioned that it was kept it for auction, lordship.
No, my lord.
No, what he
no.
said, the road roller in question was parked in so-and-so
Yes, lordship.
along with part 2, and it was under supervision of
the
PWD.
PWD, lordship. That's much, lordship. No way it was mentioned that it was placed for the auction or
Ah,
whatever,
yes.
No,
lordship.
I have never stated that, madam. I have never stated.
No, it is
No,
statement.
you have stated before the IO that
That-
you said Amin Hussain.
Because I have to sell that thing.
You
That's
have to
why.
sell.
That is only the part.
This is what I have stated.
Yes,
It's okay. And she has pointed out that it is not for sale and all.
Yes,
it is
yes,
still
yes,
under.
Yes, lordship.
my lord.
She has also placed the 161 statement of the complainant, wherein he had stated that the road roller was under the supervision of the PWD.
The road loader in question, lordship. It was in the road loader in question. The same road loader was
yeah.
in the.
The road roller in question was under the supervision of the PWD. And that nowhere he had stated that the said road roller was auctioned for sale by the government.
Lordship, in the trial also, lordship, if nothing is found, then he could be discharged there also.
Yes, of course. But then he has come for quashing. Let
Yes,
me hear
lordship.
the other party.
Yes, lordship.
Otherwise, it will be a futile exercise.
Yes, lordship.
Trial court. And then heard both the parties at length. And it is revealed from the petition that the informant had entered into an agreement with the petitioner, and that he has been arraigned as respondent number 2. Since he is not represented today, let the notice be issued upon respondent number 2. You want to do it by Dusty and all? Do it fast so that
My lord,
Dusty not possible.
not possible, my lord. It's Mariang, my lord. And I'm not aware, my lord, where he's posted now, my lord. To the
Register post.
By register post, he is a government.
Yes, my lord.
He is still working there.
Yes, my lord.
So by the petitioner to take steps for service of notice upon respondent number 2 by AD, by registered post with AD, returnable within 3 weeks. 2 weeks.
My lord. Interim prayer, my lord. Only till the returnable date, my lord.
There, lordship. And here, lordship, informant not came before the court for the affidavit swearing also. How can we, lordship, assume that it is joint petition, lordship? And whereby, lordship, this
What about the signatures and all properly
lordship,
put?
that's why, lordship, we don't know anything, lordship.
It is not a joint petition, my lord.
Joint petition, but where is no joint petition, lordship?
My lord, it is necessary that since there is a settlement, there is to be a joint petition, my lord. It is not necessary, my lord. I am the person who is aggrieved. I have come, my lord, before this.
Returnable date, let him come and
My lord.
otherwise,
Yes,
if they
but
want to
they-
settle, he is a young boy, so of course 379 is
Let
made out.
lordship, he comes, lordship. After that, if lordship, if they have lordship, actually they have settled, they have no problem, lordship. Joint petition, this petition can be revived at that time also, lordship. But the thing is, lordship, whether this respondent is have any knowledge of this petition or not, lordship.
So no, as of now, we are seeing this settlement agreement.
It was agreed
But then
for the notary, my lord.
every matter cannot be settled.
Yes,
My
lordship.
He sold a government vehicle.
That's
He is
it.
also
I am admitting
a
that.
boy.
But-
And then
But then, my lord, I kindly appreciate that, my lord. This was a settlement deed which was executed before the notary public, my lord. And at least we cannot, It is here, my lord. The stamps and the signatures are here, my lord.
Then why not joint petition?
Now, everyone should get an
Yes,
opportunity to reform himself. Let's say young boy, let it be stayed. Then on the next day, if he denies, then the matter will be gone.
Let the,
Lordship, I leave it to court. It's past any order as per the justice.
A young
Yeah.
boy, I'm saying. This further, in view of the settlement entered into between the informant and the petitioner, and that the petitioner has tendered, which demonstrates that the petitioner has tendered his unconditional apology. And that on the consideration that the petitioner is a young boy in his peace, the further proceeding of the this is GR cases, it is registered GR case.
yes, ma'am.
Further proceeding in connection with the GR case number 32 of 23. 32 of 23. How can it be 23? These are not years or what? GR case?
I'll just check it, ma'am.
23, we state till the next returnable date. Till the next returnable date.
It's only till the next returnable.
Okay. List this matter after 2 weeks on a date to be fixed by the registry.
Lordship.
You give the number.
Yes, my lord, it's GR case, GR 32 of 23.
This the subsequent number, the second number is not related to the year.
No, my lord, I think as far as,
It's related to year actually. 23 is a year. Lordship.
But then no, charge sheet is 24. How can it be? I mean, the FIR is 23.
FIR is 23, ma'am.
GR case number 32 of 23 in connection with FIR number 7 of 23 dated 5/9/23 be state
Deeply aware.
till the next return. Listed up.
All right.
Please, my lord. My lord, by way of in this application, my lord, the petitioners,
Criminal petition, okay.
my lord, the petitioners are seeking the indulgence of my lord for quashing of FIR and the subsequent charge sheet, which has been registered under section 121, subsection 1 of the BNS, which is perimeter to section 332 of the IPC, my lord.
394.
332, voluntarily causing harm to deter public servant from official duty,
Okay.
solely on the basis of settlement.
Solely on the basis of settlement again.
If my lord may
All
have
cases
kindly,
are settled.
settlement is at page 41, my lord.
Now first let me go to
FIR. My lord may have page number 19.
page number
191.
19. Yes.
On 18/4/2024, at about 14:30 hours, a telephonic information received one Miss so-and-so, Naharlagan, that a person who is her boyfriend is attempting to commit suicide at a rented house located at D sector, Naharlagan. Accordingly, self with a ready party left
Nabam James is the one who tried to commit suicide.
Yes, ma'am.
Okay.
Attempted, ma'am. Outside the room of the complainant. Accordingly, both the parties brought at PS for further verification. In the meantime, the parents of the boy appeared at PS and they started quarreling with each other verbally. I have instructed the sentry on duty, Constable Indravati Devi, to intervene and control the situation. When Constable so-and-so on both the parties, the complainant Miss so-and-so assaulted Constable so-and-so physically with her cell phone and injured her.
Oh, the mother.
My lord,
No, the complainant, the
Yes.
girl.
Girl, my lord. That was out of the heat of the moment, in fact, my lord. There is no mens rea as such. My lord, if my lord may kindly have page number 22, that is the injury report, my lord. The injury report has been classified as a simple injury, madam.
Simple.
Simple
Left
injury.
side of her forehead, left side of the forehead and lower eyelid.
Based
Simple
on this, my
injury.
lord, the investigation was carried out, and eventually, my lord, the charge sheet has been filed.
Hmm.
If my lord may have page number 23, that is the copy of the charge sheet, my lord.
Hmm.
Next page.
26.
Forwarding of charge sheet number so and so, dated 31/1/2025. The offense has been charge sheeted under 121 section 1 of the BNS.
So here, she or he, she was charge sheeted under? She
Section
was
121 subsection 1 of BNS.
for obstructing the officer.
Right.
Then?
And my lord, if my lord may have page number 41,
It is the settlement.
my lord.
No, who had hit the police officer?
In this case, petition number 1 is the informant. Petition number 2 is the victim. Petition number 3 is the accused man.
No, what happened? The complainant,
My lord.
Yanga Giba.
Yes, ma'am.
She assaulted Debbie.
She is a.
So Yanga Giba is the one who had given information that her boyfriend is trying to commit suicide.
In her rented house.
And this settlement is not between Yanga. Oh, Yanga Giba is dead. And Tapu Sarke is the police officer.
Informant, my lord. Assistant sub
He is
inspector.
the Tapu Sarke, Indravati and Yanga.
Younger, my lord.
And this is a joint petition.
Joint petition. My lord, similar nature of matter which has been taken up by my lord. On 2-3 occasions, my lord was inclined to consider the application and watch the proceeding as well. My lord allows me, I'll place those authorities. The coordinate tells me.
Okay, I'll just see the parties. Okay, Tapu, Indravati and Yanga. Of course, this out of anger, because she tried to separate the parties.
Yes, ma'am.
So that they don't quarrel and fight.
Yes.
And then she out of anger because somebody wanting to commit suicide in her room and all. She was already angry and then she hit.
Out of frustration, ma'am.
Achha, what did the settlement says?
Settlement, my lord, I have.
2 women were quarreling at each other.
Right.
To the effect, second party tried to separate the parties, altercation broke out. That is injurious. Decided to amicably settle their grievances towards each other and live a peaceful life. Okay, what is the coordinate judgment you wanted to show?
My lord, in this case, my lord, the offense was 332. Now under BNS, my lord, is 121 subsection 1. Para 2, 3 and 15 I'm relying. If I may.
Yeah, yes.
The petitioner here in the present proceeding has instituted the criminal petition washing of the fire. There is so and so lodged by the respondent number 2, leading to registration of Nahalagan PS case number so and so under section 332, 427 of Indian Penal Code, along with the charge sheet being charge sheet number so and so, that is so and so, laid by the IO initially before the Court of Learned Magistrate of Body District and presently pending in the Court of Learned Judicial District First Class Capital Complex UPR in GR case number 45.
So one second. The one thing was left out in the earlier case. Miss Lakshmi Hage will produce the instruction, produce the instruction as to whether the charge sheet was submitted before the court or not. That you wanted to know, place the instruction.
Then if it's submitted, then that scan copy of the TCR may be called for lordship.
And if it is submitted, the records, the trial court records.
Scan
may also-
copy, scan copy.
Scan copy of the trial court records may also be called.
Yes,
for.
lordship. Thank you, lordship. Actually, I have to.
I forgot.
Yes, lordship.
Suddenly I remembered in the earlier case.
Para 3, my lord.
Hmm.
The respondent number 2 herein had lodged an FIR before the officer in charge of Naharlagan Police Station, Inter Alia, alleging therein that while he was posted as doctor at Naharlagan General Hospital on 21/5/1999, he was called to attend to a patient who was in a serious condition. On reaching the
Yes,
hospital,
in respect of that fact.
my lord. Therefore, eventually, my lord, in paragraph 15, my lord, the
Hmm.
FIR as well as the subsequent charge sheet has been quashed, my lord.
Hmm.
Similar nature, my lord, there are 2-3 authorities, my lord, of the coordinate bench. If my lord allows me, I can place it. Otherwise, my lord.
No, it's okay.
It's all.
What does
Right.
Lakshmi says?
Lordship. Yeah, lordship. Only the thing is the uniform. She was in uniform, lordship. That's it, lordship. Otherwise, lordship, if he is not in uniform, then the two persons are private in nature. They can be easily compromised, lordship. But it's coordinated. If it is already, lordship, it has a judgment, ludship.
What is the purpose? Like she
Yes,
was
lordship.
in a angry state and then.
Yes, lordship.
Okay. Heard Mr.
Jay Sering, my lord. Jay Sering.
This is item.
Item 6.
You are
Jay Sering.
Sering. Mr. J. Sering, learned counsel appearing for the parties, for the petitioner, and Ms. Lakshmi Hage, the learned additional public prosecutor for the state of Arunachal Pradesh. This petition is filed for quashing.
But the lordship, when everyone come before the court attacking the lordship in a uniform, lordship, then
Were fighting.
yes, lordship. That's why the appellate court also generally, if they quash lordship, they look into the facts and circumstances generally. Regarding lordship, simply because they have settled, it cannot be lordship. But here lordship, this case is different lordship. They have lordship as per the lordship case lordship. The heat of moment they have lordship this thing lordship happen lordship. And equally they if he is lordship mutually they have settled. That's not use not that's not lordship. But lordship during passing of order lordship, it may be reflected that this kind of case may be lordship. It's not for general lordship. All the cases. Yes, lordship.
This is an exceptional.
Yes,
case,
lordship.
so it's okay. For quashing and setting aside of the FIR. Dated 11/2024, registered under section 121 within bracket 1 of BNS. Yeah, for quashing of the FIR in connection with, right? In connection with Naharlagun PS case number 139 of 24 that I have said, dated 18/11/24, registered under section so and so, as well as the charge sheet being charge sheet number 12 of 2025, dated 31/1/2025, submitted in connection with the aforesaid FIR. This is a joint petition filed by the informant, who was the sub-inspector of police, who is the sub-inspector of police, Naharlagun Police Station, comma, the Srimati Indravati Devi, who is also the She is what?
She is the constable, madam.
Constable. The constable at the Naharlagun police station, as well as the petitioner, as well as the accused person, that is the petitioner, or as well as the accused person. The FIR lodged by the ASI, lodged by the informant, that is the ASI, petitioner number 1, reveals that on 18/11/2024, at around 2:30 p.m., that a person who is in relationship with the accused person, that is petitioner number 3, was attempting to commit suicide at her rented house, full stop. On being informed, the police went to the place of occurrence and found the person who was trying to commit suicide out in the police station, and they were quarreling with each other. And when the additional, when the ASI, that is petitioner number 1, instructed petitioner number 2, the sentry on duty, to intervene and control the situation, petitioner number 3, the accused person, control the situation, the petitioner number 2, the constable, tried to separate both the parties, and at that juncture, petitioner number 3, the accused person, assaulted the constable with her cell phone and injured her. The police, after completion of the investigation, submitted the charge sheet as mentioned above. And 121 within bracket 1 BNSS charged petitioner number 3 for assaulting personal duty at police station Naharlagun and arrested the accused person. The counsel appearing for the petitioner submitted before this court that the petitioner number 3 that is the accused person, had no intention to assault the constable who was performing her duty in the police station. But in the spur of the moment, without any evil intention, petitioner number 3 hit her with her cell phone and injured her. He also placed the medical report of the petitioner number 2, that is the constable, which he had annexed as Annexure 2 in his petition. And the said medical report reveals that there was bruise with swelling on the left side and were caused by blunt impact. The counsel for the Mr. T. Seri. J, no? Okay, J. Mr. J. Seri, learned counsel for the petitioner, also has placed a deed of mutual settlement entered into between all the 3 petitioners, that is the informant, the constable, and the accused person, which he has annexed as Annexure 4 in the writ petition. It's the what? The middle is it? Okay. It is stated in the said deed of settlement. It was agreed upon. It was agreed upon in the said deed of settlement that all the 3 parties have amicably settled their grievances towards each other, and that the accused person, that is petitioner number 3, after realizing her mistake, it is his mistake in this.
Her mistake.
This is copy paste, I think.
Yeah, to some extent, man.
Lordship, I have Lordship one query, Lordship. In the page 44, Lordship,
Huh.
settlement agreement, Lordship, the second party, which is the Lordship, constable, Lordship, in the well, signature, Lordship, is
Indravati Devi.
yes, Lordship.
Which is in Hindi.
Yes, Lordship, because he's siege, Lordship, constable, Lordship, a government officer, Lordship.
And
Scan computer teacher may be called for Lordship. We don't know which stage is going on, Lordship, is trial court, Lordship.
Or it has to be sent to FSL then for checking her signature and all. But then she is appearing through him. See the affidavit, Tapu Sake. So and so, I'm petitioner number 1 as are fully acquainted. But then he has not been authorized by the others.
no, madam, they have filed separately. 3
Oh,
affidavits.
separate.
Page number
Achha,
15,
achha,
madam.
Okay. This is by Tapu.
Madam.
Or by Indravati. Let me see her signature here.
Page number
Oh.
16, madam. Same.
Same signature, see, at page number 16. Sign this affidavit. "55 years of age. He is constable. Let me check both the signatures. E is same.
They're all
Signatures are same.
genuine signatures, my lord.
And then this one. Miss Lakshmi, I find the signatures different. Different. Huh?
Okay, Lordship, as he is, her age is 55 years old, then he can be Lordship.
He is a constable
Yes,
from,
Lordship.
from other state.
Yes, Lordship.
She is a Hindi speaking lady. Let me see, let me dictate. What did I say? On the deed of settlement. He has tendered apology, something I said. After that. Her mistake, sought for an unconditional apology to both the parties and had also offered to bear all the medical expenses of petitioner number 2. Of petitioner number 2. The said agreement was entered into on 2nd day of June 2025 in Naharlagun, Arunachal Pradesh. As such, Mr. Zering, no? As such, petitioner number 3 had in fact assaulted petitioner number 2, who was the constable, while she was discharging her official duty and had caused injury on her body. And that the offense under section 121 within bracket 1 of BNSS is well established against petitioner number 3. She stated this is not a small incident and the same serious repercussion on the society in as much as a police official on duty was assaulted. She further states that these kind of cases cannot be settled by way of a mutual agreement between the parties. She also stated that if cases are quashed on such settlement, it will send a unpleasant signal, unpleasant sign to the society at large. And what else you said? About the signature, I'll not go into.
No, Lordship, that is to
Not
call
required.
leave it, Lordship.
And
Also, Lordship, if there's nothing is Lordship, they can afresh the trial court also that they are going to settle Lordship. And at that point of time, Lordship, it can be Lordship because
no, this is not.
yeah, they are Lordship, but they can afresh before the court Lordship. That can be done Lordship. And that point of time, they before they actually usually what trial court would do Lordship, non-conforming offenses Lordship, they before the court they have read out Lordship. Then at that point in time Lordship, the 40 party they have generally they have settled Lordship. They apply the court that we will going to settle Lordship. They come to before this High Court Lordship. They have take some time and before file the joint petition before the court Lordship. They think Lordship if they have Lordship.
No, if I quash, they need not go
Yes,
to the trial
Lordship.
court at all.
Yes, Lordship. That is their Lordship. That's why Lordship, my submission like that, Lordship. If they have Lordship mutually settle Lordship, if they have intention to settle before the between themselves and they have to Lordship apply before the court also Lordship, that thing Lordship before the court Lordship, High Court has the power to settle Lordship under 528 Lordship. They have not that power Lordship, the compound the non-compounding offense Lordship. In that case, Lordship, if the Lordship they have mutually settled Lordship, then they is before the Lordship.
Not getting your point. Like, what do you want to say? They cannot go before
Yes,
the court because it's a non-compound.
Yes,
It cannot
Lordship.
be allowed.
Yes,
They need to
Lordship.
come to the high.
Yes,
Court.
Lordship.
So they have come, and
Yes,
now,
Lordship.
if I quash, they need not go back. To the
Yes,
trial.
Lordship. That's why Lordship in the before the court, what stage is going on, we have don't know Lordship. We have no idea Lordship because as already charged stated Lordship.
They will now go and tell them that it has been settled.
Lordship, by its order Lordship, if Lordship has passed the order, they have produced this order Lordship before that, and it will be Lordship quashed already Lordship. They have produced that order before the court Lordship.
Okay, that I will say.
Yes, Lordship.
That they will place the
Yes,
order.
Lordship, that
before.
is their Lordship.
Okay. Now it is one, and rest of the part I'll dictate it in the chamber.
My lord.
I'll allow the petition.
That's it.
I'll give some Supreme Court judgments on that.
I have.
Oh, you have some. Just give me. There are a very renowned judgment. What was that?
Lakshmi Narayan, Quashing and all this one.
Uh-huh.
I have it also.
Lakshmi Narayan.
Full bench judgment.
Acha.
I've placed two other judgments, my Kapil Gupta judgment as well as the.
Now you are placing this only, right? Okay.
But there Lordship in this judgment also Lordship, there are only the civil dispute Lordship, settlement Lordship.
Means Lakshmi.
Yes, Lordship. They are the
Where there is judgment where so many categories are
Yes,
prescribed that in these cases settlement,
Yes, Lordship.
not in heinous crime and all.
Yes,
What was
Lordship.
that? That was a very renowned.
Here Lordship.
Lakshmi, no, that was not Lakshmi. I was.
Quashing also, Lakshmi Narayan in paragraph.
I think they have referred to one judgment here.
Para 13, it has been categorically mentioned.
We have given, and now you have given two copies. One copy would suffice. Okay, I'll see this and I'll pass the order in the chamber. Yes, in the chamber. Rest of the part I'll give it in the chamber. Not now, afternoon. Okay. Yes. 7. Okay.
I'm presenting the order part to the magistrate under section 143 of 11 Interstate Discrimination. Page number 51.
The other party has to be heard. since it's a NI matter. Because she is only a former party. What are you referring to? Yes. This is the order you have challenged? Yes. 17-3. Now, what does it say? Just read the order once.
I will see the order.
May I read that? Considering the grounds, I'm inclined to.
Direct. Complaint is declared 50% of the state. And then the order, I have, before passing this order, I have, what I think, because of the application form, permanent order, I have filed objection. Before this, but without recording any reasons, the court has passed this, you know, you look at his check is clear. Yes, whereas this provision is mandatory, directory and hardship justification, whether
I have to look into that point because
relying on this.
Just a second, let me read. One second, I'll come back to you. So what, Supreme Court? Wait, what is the provision for payment of interim compensation? 142?
143A, Your Lordship.
143. Give me an act. Do you have? Or if Jeannie has. Yes.
143.
This is interim compensation. What about double the amount of the check that is provided where? Case is still to be heard.
That means yet to be tried.
Yet to be tried. Okay.
We will be defending the case. But without making out any prima facie case, any payment liability, without recording the results, which is wrong.
Okay. Prima facie, it seems there is no reason.
Prima facie is 30. The company has 30 prima facie. There was a monetary liability. That is the number. And number two, while passing the order, what has to record the reasons.
Where is it? Just read 143A.
Yes.
Ms. Dini? Yes, Your Lordship. Yes, interim compensation. Shall not exceed 20%, so he has given 15%. Yes, that is not an issue. Otherwise, in the provision, nothing is stated.
The petition part of this provision is
This is by Justice Oka and Ujjwal Bhuiyan. paragraph? What is the paragraph?
Paragraph 18 and 19.
18 and 19. Okay.
How or provision is and if you order or set aside an application made by the complainant, a complaint petition number that is under section 145 43A 1 of the NIA. Responding to the file of the judicial message of
And this is the conclusion. What are the findings on this?
this finding page number 19, paragraph 19, the directory. Paragraph 19.
These directions. The exercise of power.
Power. 143 directory. Provision directory is not mandatory. No name is the provision cannot constitute as constructive as said. While deciding the prayer made in the section 143, the court must record brief reasons indicating the consideration. The broad parameters for executive execution under section 43A are as follows. The court will have a prima facie evaluate the merit of the case announced by the complainant and the merit of the defense needed by the accused in the class. The application. Financial distress is totally considered.
So depends on merit of the case. Made out and
Found to be prima facie possible, the court may exercise discretion in refusing to grant interim control. Because no case has been made out, although the sick has bound to be bound.
if the court concludes, the rest of it are not required. You may also apply his mind to quantum. Okay. So why are you saying that the case is not prima facie plausible?
I see. That case is established by the page number 32 elected file. Although the stating question was issued, that is not issued, not issued by me. That is still and presented field by himself and presented to
You are denying the check you have not issued.
Yes, I have not issued this check, but to his mother, her mother.
Achha. To the complainant's mother.
Yes. During the course of cross-examination, what he is in court, and page number
52.
52 of 9. May I read the question?
Yes.
Education is
stating yours, this is cross only.
It is a fact that I have to prestate to the request amount to rupees
10 lakhs and 2 checks of 5 lakhs.
5 lakhs. I have name check with cash and request cash. Was debited from my account. The correct date of the agreement is in 5/2014. It is expected remaining amount of 64 lakhs was given to her in cash. To conclude installment, that is the 20 days of portfolio. It was given in the month of January and February.
No, initially she says who had taken the money, I don't know, but it got debited from my account. So again, she talks about her. Who is she referring to?
The petitioner here, Your Lordship. She has issued 3 checks to the petitioner, Your Lordship.
Mipet time.
Yes, petition.
The petition.
Yes, petition. This is the situation of the complainant. The defense side. And there the petition is filed by the defense from defense side. Then during the course of trial, yes, before that, that amount was given in check as well as in case. Case was in 64 lakhs out of 84 lakhs. That was a 24 lakhs, 20 lakhs was given in case and 44 lakhs was given in. And here she said no money issue was issued to me. No money issued. I paid the case amount of 64 lakhs to her and.
No, wait, we are reading where?
Well, account my mother. Issued a security check. check was a security check, not for this picture of life. She gave me the blank check and security. It is a blank check. The check amount was retained as security check. She gave me the blank check and security. Check amount was retained by me in presence of security when the undertaking of security. Till that, no amount is presented. This is the basic. The confusion is that he is claiming, the company is claiming that some amount was given by check and 20 lakhs plus 64 lakhs was given. But there was no such money and the check was a blank check, which was a security check.
Okay.
But that security check has been presented to the concerned bank.
Oh, there were some.
Letter and found to be done. This is the side of the complaint. And page number here, page number 54. This is her complaint, the biggest. What she is saying?
54 is?
54 is the complainant witness. That complainant.
Her witness.
Her witness.
She was present when the agreement was executed.
Agreement was, here is the agreement on the basis of agreement. Prior to the agreement was executed, some transaction has occurred prior to the agreement. As because the terms of the transaction were not honored, agreement was executed. That is it. We are stating that agreement was even not done then. We are activated the fact that the security check was given to her mother. Because her mother and we are having some this transaction. And therefore we were having. We do not know this complaint because we do not have to get any connection. Even then, one agreement was brought and security check is question as is presented, whereas I have not given any security check to her.
But to her mother.
Not her mother, to her this complaint. And conducted one complaint is also there. Her mother is a file me. But this case is actually connected with has forced the file against me. So there is I do not have any business connection with.
So what you mean to say is you have not given any money to the complainant?
I have not taken.
Yes, you have not taken any money from the complainant? Check that you have given me were given
to her
mother, not to her.
No.
And that was a security check?
Security check, yes.
Not for discharge.
Not in discharge of any liability, but only to her mother. No connection, no transaction with the complainant. That is what your submission is. And because of that, no interim compensation could have been allowed on the merit.
I doubt to fashion. Interim compensation not be given. So if that direction is given, I have to arrange money. Because when I do not have money, I have not taken. After that circumstance, how I can arrange it. This is for the convenience balance of balance of party balance of the convenience of the party and for them to see whether prima facie case established by the party or complainant or not. That is
okay. Today it has come up for admission.
Yes.
And what does
yes, Your Lordship, I'll just
we'll have to hear the other party, but I think he'll pray for interim.
yes, with regard to interim, Your Lordship, I'm here just to assist the court, Your Lordship. Because Your Lordship cannot go unnoticed of the page number 27 is the agreement, Your Lordship.
Page number 27.
Yes. Your Lordship will see the type copy at page number 30.
Let me, this is readable, so we
Yes,
can
30,
also go
Your
by the,
Lordship.
yes.
I, Srimati Mipet Taing, who is the present applicant, Your Lordship, wife of so-and-so, daughter of so-and-so, resident of so-and-so, PO so.
Received a
This
sum
is sum of 84 lakhs only from Miss Mama Tang, who is the respondent number 2 here, respondent, Your Lordship. Daughter of late so-and-so, POPS, AP, on 17/12/2019 on good faith for some personal works, promising to pay back the said amount within a period of 1 month. That due to some issues, I could not pay the said amount within promised period. I therefore hereby acknowledge that the amount was received by me through check and cash whose details are given below. The check which I received from Mamatang was drawn by some others but have received by myself from the lender. That I hereby further promise on this day.
What is she said? Was drawn by some other.
Since the check was given to her, Your Lordship, it was drawn by some another person, but one was received by
Myself.
herself. That I hereby further promise on day of 10/5/2022 that the amount of 84 lakhs only shall be paid within a period of 1 month from today. So the contention, Your Lordship, the deposition given by the complainant here is that on the previous occasion there was a promise that within 1 month she'll be paying, Your Lordship. She did not pay, and thereafter this agreement was made by both the parties that she'll be returning this amount, wherein a detailed number of the check and also the cash given to her has been reflected, and it is the witness. Your Lordship will see the first witness, second witness G. Riba.
One second. This is. Yes.
The agreement, the witness in the agreement, G. Riba, is at page number 54.
Page number 54.
54, Your Lordship. She also substantiated that on, Your Lordship, if I may read, Your Lordship, I was present when
the witness of the
this execution of money received. She states that from the second paragraph, I only heard about the previous transaction but did not personally witness, because on the previous transaction there was no agreement. Subsequent agreement, at the time of agreement was executed, 1 month time was sought for payment of the money, and in default, the check which was given to the complainant by the accused could be presented for encashment. She is a witness to the agreement, Your Lordship. Therefore, they cannot deny that there was no transaction between. Now, even the complainant herein clearly says that the check, a blank check was given to the complainant as a security, Your Lordship. Now, when she was repeated calls made an endeavor that to get back the money, which she did not comply, and therefore she had to get the check and cashed, Your Lordship. It's when it bounced. Now, Your Lordship will see that this order was of, if Your Lordship will then come to page number 51, this order is of 17/3/2025, Your Lordship. The impugn order. Subsequently, Your Lordship will then come again to page number 54. Your Lordship will see that the deposition of the witness was done on 15th May 2020, Your Lordship.
15 May 25.
2025, Your Lordship.
So after this.
Thereafter, Your Lordship will then come to page number 56, Your Lordship. Your Lordship will see that it's a order dated 19/5/2025, Your Lordship.
After her deposition.
After deposition, bailable warrant was issued to the applicant, Your Lordship. It is only an afterthought that since bailable warrant was issued, hence coming to this court, because the cross was also done to the defense witness. At that point of time, they never felt it the necessity to come before this court challenging the impugn order, Your Lordship. This is just an afterthought only after the issuance of the bailable warrant, Your Lordship. At this stage, my humble prayer, since I'm just a performer respondent, Your Lordship, I'm just assisting the court, that at this stage, Your Lordship may issue notice, because hearing the interim, Your Lordship, at this stage,
after he appears. Yes. This is what is, this is seen from the records that the agreement that she has pointed out, it was between you and the complainant. And then.
I have signed that is right. That is in my defense. Say that I have never signed such drawing such agreement, and I have never shoot such check. I have never signed any check. That is it. That is completely forgery.
And the forgery, this can be made to the.
Okay, let the other party come, but then the interim will be considered only after he comes.
Yes,
on the next day.
Your Lordship, after hearing the parties, Your Lordship, because again,
after
notice
is heard Mr. T. Tapak for the petitioner, the learned advocate for the petitioner, as well as Jeannie for the additional public prosecutor for the state of Arunachal Pradesh. The incident case is filed against the the instant case is filed challenging the order dated 17/3/2025 passed by the learned Judicial Magistrate First Class UPR Papampare, Arunachal Pradesh, by which in complaint case number 78 of 2022 under section 138/142 NI Act, by which the learned court directed for payment of interim compensation to the complainant at the rate of 15% of the check amount within a period of 60 days. Full stop. The said order was passed by the learned court after considering the grounds made out by both the parties. Of course, it did not give reasons, but then one word is said after considering the grounds. The learned counsel appearing for the petitioner, Sri Tapak, submits before this court that the direction for payment of interim compensation to the complainant was not called for in the facts and circumstances of the case. He submits that the petitioner has no liability to discharge towards the complainant and that she had never issued the checks. Sir, she had never received any cash amount and has never issued any check in favor of the complainant. He as such submits that the agreement or the checks issued in favor of the complainant was forged, full stop. On the other hand, Miss Ginny, what Ginny?
T. Ginny, Your Lordship.
T. Ginny. On the other hand, Miss T. Ginny, the additional public prosecutor, submits and places the agreement entered into between the petitioner and the complainant annexed in the present petition. In the said agreement, it was clearly stated that the petitioner had received an amount of rupees 84 lakhs from the complainant on 17/12/2019. Total is 84, right?
84.
By way of 2 checks or by way of 3 checks or 2?
It's
by way of check.
3 checks, Your Lordship.
By way of 3 numbers of checks and also by cash. As such, she says that the petitioner has a liability to discharge towards the complainant. Before his submission, you write one line that he also submits that money was the petitioner had issued bank check as security to the mother of the complainant and not to the complainant. He states that the petitioner has no monetary transactions with the complainant. I have heard the submissions made at length. Para, issue notice to respondent number 2 by registered post with AD.
By publishing the name of the respondent.
That will come as a last resort. Try through the normal process. Okay.
Since this is an IT case, Your Lordship can also direct for dusty service in this matter. No issue.
Payment report.
Achha, that next date is when?
17 July 2024. Report of a payment.
Page number?
Page number 56.
The bailable warrant issue.
So fixing for so-and-so on report of bailable warrant.
You can go for dusty service, Your Lordship.
So you can serve it before that, 17th of July. Can you serve it by hand?
No, publishing.
That will take long. He is known to you. She is known to you, and you can you serve the notice by hand?
Yes. Her address is also at E sector, Naharlagan itself.
You try by registered post as well as usual process. Registered post with AD, returned by 3 weeks, and returnable by 2 weeks, or 1 week, whatever. Returnable by 1 week, along with the usual process. The petitioner to serve the notice upon respondent number 2 within a period of 2 days from today may take steps for service. And the interim order, list this matter after 2 weeks. The interim order may be considered on the next date upon appearance of the respondent number 2. Okay. Scan copy. It is required, Ms. G.
Yes, Your Lordship.
The records, the scan copy of the records pertaining to the complaint case number 78 of 22, pending in the Court of Judicial Magistrate First Class UPR, District Papampare, Arunachal Pradesh, is called for.
Deep blue. Okay.
To be listed after 2 weeks.
Deep.
Yes. For settlement. Okay. What is the offense? Huh?
380 IPC.
380 is stealing.
Step from dwelling place.
From the dwelling place.
Yes.
When I was in Mizoram, I used to hear that people there mostly enter into settlement. They hardly come to the court. And
Yes.
then here also I'm finding it. Which page? 20. Okay. Is it a longer? Okay. Yes.
To the effect date on 20/5/23 at around 20:16 hours to 20:30 hours. An unknown person entered into the apartment, restored her money, access kept up from her room, and registered a case by immediate case under under section 380 dated 29/5/23. Endorsed me to investigate in case of investigation. During the post investigation, the PO photographs of the statement from different users examined and recovered the statement of the complainant under section 161 CRPC, which cooperated with the then FIR. The footage was the department of becoming so which arrest accused person was identified as 1 billion Bloom Drive.
He is the petitioner?
He is the petitioner.
2. Uh-huh. Hmm.
Then on 29/5/2023, evening hours around 17:30 hours, arrest accused person Villain Bloom Drive. The was apprehended by the complainant and her relatives with stolen laptop from the premises of the apartment. Accordingly, he was arrested by the investigation of case as informed by the complainant by observing all legal formalities, presence of his elder sister Miss so-and-so, and since the stolen items from his possession. Later, recovered items were handed over from Zimanaka to the owner in the presence of witnesses. The arrested accused person was examined.
What about the cash? Cash was not recovered. Okay. Hmm.
The arrested accused person was examined and reported a statement under Section 161 CRPC, where he confessed his involvement in the case. The arrested accused was forwarded to RTO for where he found it and gave the police custody to the other station. Then on 35/23, forwarded the arrested to the police with the prayer for police remand for 2 days, which was accepted by their number so during the 2 days police remand, the arrested accused person has been interrogated in similar case registered in the police station, but the accused person has not been found involved in any other cases. Then on 1/6/23, forwarded the arrested to the Honorable CGM Court with a prayer for judicial custody after expiration of 2 days remand in police custody. Accordingly, the Honorable Court has accepted the prayer and the arrested is tested of COVID found negative in the COVID test. The arrested accused person has been sent to 14 days judicial custody. During the post-investigation process and interrogated in relation to other pending cases, the arrested accused person, Sri Milan Punungai, has not been found in both cases. The crime may have been committed due to presence of alcohol. If you also see the 161 statement of the accused person, wherein he has confessed that he was under the influence of intoxication, and the amount was of 700 rupees that he had already spent. That's why the amount was not recovered.
Achha.
Thereafter, the case
But then this alcohol is not an exception unless it was administered forcefully.
then the age of the accused person was commonly considered. He was only 19 years of age at the time. And the complainant as well, considering that the age of the accused person was only 19 at the point of commission of death, yes, she has
Entered into that.
The second is the place number 50.
Hmm. 31, this is an order. This is an order by charge. Oh, charges are framed. Okay, charges 380. Trial is on. Then settlement.
And both parties that are not included their own disputes in the state of the state and first party has no objection if the case pending against the second party is caused by the Honorable Court. There are three of the next page. Then the second party is tendered an unconditional apology and further and takes not to which the same state future. That is settlement is being entered into the filing of the petition for Quashing for Honorable Court under
So only on the ground of settlement you want quashment. Okay. Miss Kipa Napak is 27 years. She is the complainant. And this Milan is the accused, 21 years.
Who went to the accused person after committing the offense on 28 in the state of drunkenness. I felt bad and I went the next day while I was to deliver the property stolen and registered the case. There's the
Where is this 161?
161 is the page.
22? No.
Page 22. On the second paragraph. On one side, there is on 29/5/2023, I was feeling sorry for stealing So I decided to go back to the building from where I saw the laptop. In the case to return it back to the owner, but the case has already been spent in the evening. When I was proceeding to the building, I saw a girl was calling me to come. Then they apprehended me and informed to the police, and the police took me to police. Since they had already this person in the CCTV footage, they could recognize him that he was the
But whether the police said that he arrested him under such circumstance? Where where was the charge sheet? Huh? Oh, okay. Huh. Oh, apprehended by the complainant and her relatives with stolen. Acha. And what do you say? Yes, learned public prosecutor. You are
Your
Mr.
Lordship, matter has been amicably settled.
Acha,
And,
you are Mr. Deloy.
No, I'm G Tado.
G Tado.
Yes.
Okay, so G Tado. You didn't getting confused with the names. Okay, so you don't have any objection.
Yes, they have already amicably settled. Down the
And this
matter.
is not a heinous crime.
Yes,
That it cannot be settled.
extended up to 7 years only. Punishment. That means
380 is now also 7 years. Theft,
no, 380.
indwelling place.
Yes, it is in
Now
IPC.
also, right? Menace also.
So there are only 3 prosecution witnesses are there.
Yes.
One,
And what, let me see the affidavit filed. There are 2 affidavits or 1? 2. Ipanapam, her, and Milan Tholung Rai. Let's see here, their signatures once. In the Ipanapak is. Okay. Milan is okay. See the signature of Kipanapak. Kipanakap. It is little different. See compare the signatures in the affidavit and the agreement settlement. No, affidavit in this. The affidavit that is sworn in. But there is some difference in the signature. Just see once.
in my copy, there is no signature at all.
Oh, acha. Okay. The A is a little different.
Your Lordship, before disposing this matter, status report needs to be produced because as per the petition, page 31, one order sheet. Yes, page 31. CC was done on 27/7/2023. Now there are only 3 witnesses. Now it is 24.
25.
Yes, no, 24,
What is
6,
the
25.
stage of the trial? For 3 witnesses, they are taking so long. But then what happened to the trial? Let me see that. What has happened to the trial?
Yes, status report at least. And if
the trial is over and all?
yes, if applicant is claiming youthfulness of 18 or 21 years,
What?
if applicant is claiming the age
Factor.
yes of youthfulness of age, then that may be in the that record may be available in the LCR.
Why we have to see this? This is it is almost 2 years since
Yes.
the charge is framed. So maybe the trial is over and all. Acha. Because settlement can be done even at the appellate stage. No issue. But then the considerations are little different. So I'll give you the interim and let the records be called for, and
Yes.
then we will final order. Okay. Heard Mr. M. Tanzang, Moses Tanzang. So Moses is a beautiful name. Moses, the prophet. Yes. M. Tanzang appearing for the petitioner, and Mr. G. Tado,
Yes.
the learned additional public prosecutor for the state of Arunachal Pradesh. This instant criminal petition is filed under section 528 of the BNSS 23 for quashing of the quashing of the case for quashing of the case being GR case number 63367 of 2023. That is state of AP versus Milan Thulung Rai, pending before the Learned Court of Judicial Magistrate First Class UPA. The petitioner in the instant case has prayed for quashing of the same only on the ground of deed of settlement entered into between the petitioner and the complainant. Mr. Tanzang submits before this honorable court that the deed of settlement has been entered into on 21st June 2025 with the stipulation that both the parties have amicably resolved all disputes in respect of the said incident, and the complainant has no objection if the case pending against the petitioner is quashed. It was also stated in the deed of settlement that the petitioner has tendered an unconditional apology, and he further undertakes not to repeat the same mistake in future. Mr. Tanzang has also submitted before this court that the petitioner was under the spell of alcohol and committed the incident without any evil motive. He, in fact, by showing the statement of the petitioner recorded under section 161 CRPC, had stated that the petitioner, when was the incident happened? 25, right? Showing that the petitioner on the very next day of the incident felt sorry for stealing, and he decided to go to the building from where he stole the laptop and cash to return the said items. The petitioner also stated before the police that when he was proceeding to the building, he saw a girl who was calling him, and then he was finally apprehended by the relatives of the complainant and handed over to the police. The Learned Counsel therefore states that the petitioner is not a staunch criminal, and he did the incident on being intoxicated, as could be from the records. Oh, at the first line, this is a joint petition, both by the complainant and the accused, filed under so-and-so. On the other hand, Mr. Tado, G. Tado, the Learned Additional Public Prosecutor, states that that in the instant case, the charges were framed against the petitioner under 380 IPC way back on 27/7/2023, and that the total witnesses to prove the charge against the petitioner were only 3. Since it is long from the date when the charges were framed, he as such prays that the records may be called for from the Court of Judicial Magistrate First Class, Capital Complex at UPA, in order to see the present status of the trial. The prayer made by the learned additional public prosecutor is allowed. Full stop, para. The scan copy of the, I just saw the order, now I'm not getting it. The scan copy of the order, the scan copy of the trial court records pending in the Court of Judicial Magistrate First Class, Capital Complex at UPA in GR case number 367 of 23 is called for. Further, para. It is seen that the instant petition is a joint petition filed by both the petitioner and the complainant. And they have prayed for quashing of the proceeding on the basis of the deed of mutual agreement entered into by both on 21st June 2025. Wherein it is further noticed that the petitioner has tendered his unconditional apology with the further prayer that he would not repeat the mistakes in future. It is also seen from the records that the petitioner is only 21 years of age and is very young. And since, very young, full stop. Since it is also seen that he, on the next day of the incident, tried to give back the articles that he stole from the complainant, this court takes a lenient view in the case at hand. As such, this court, the proceedings, this court directs that the proceedings of the GR case number 367 of 23, pending trial before the learned court of JMFC UPA, is stayed till the disposal of the petition. List the matter after 2 weeks on receipt of the records from the learned court.
Paper book is ready. Your Lordship, service upon the victim is still awaited, Your Lordship.
Item number 10, right?
Yes, Your Lordship.
Boxer matter?
Yes, Your Lordship.
Okay. To what victims? No instruction.
No instruction yet, Your Lordship.
Okay. Let me see. Notice upon respondent. Okay. Is not yet received. Appellant, you are amicus. Legal aid counsel. The learned legal aid counsel on behalf of the appellant and Miss T. Jeannie, the learned additional public prosecutor for the state of Arunachal Pradesh. It is seen from the office note dated 23/6/2025 that service report in respect of respondent number 2 has not been received from the officer in charge, police station Pasighat. The learned additional public prosecutor prays as such, the learned additional public prosecutor prays for some more time to get instruction from the said police station. She is as such allowed 2 weeks time to get the instruction. List the matter after 2 weeks. Deeply. This is for admission today, right? Affidavit in reply was filed. We have gone through the affidavit. Matter is otherwise ready.
My humble submission is pleading is about my lord. Stay order operating against me. Therefore, my lord, my humble submission, let it be disposed of, my lord. Issues only.
All the respondents are served.
Yes, my lord. I am for the respondent, my lord.
Achha, I'll just see once. There are 2 respondents only.
Yes, my lord.
You are appearing for both.
My lord.
And the petitioners are 3 in numbers. Okay. Yes. Otherwise, it could be taken up for hearing. There are bail hearings and other matters, right? If I hear this, this will take long.
My humble submission,
Let
my
it
lord.
be taken on a hearing day, next week, any day, or this week also, Friday and all, Thursday. What are the hearing days here?
Not particularly.
In Guwahati, we have Tuesday and Thursday as hearing day. Tuesday and Thursday, same here. Right. So you do it next week, Tuesday, on the hearing day?
Only my issue is, my lord.
Because I think this will take some time. Even I'll have to go through.
Issue is, my lord. Issue is very simple, my lord. He has only challenged the Parwana, my lord, that is summoned by the village authority, my lord. My humble submission, this CRP is not maintainable at all, my lord. All the
We'll
issue.
hear it finally on Tuesday or this Thursday. Next week, Thursday.
Next week, madam, I'll be not able.
Oh, then do it day after tomorrow. Okay. On the prayer made by the parties, list the matter on day after tomorrow. You write the date. 26th of this month.
Obviously.
For hearing, make it for hearing. Wait, these will go where? No, Rakesh Ranjan was for a different case. This will go here. For which case? Rakesh Ranjan, Oka and oh, that is for this one. Check. Check. Compensation. Yes. This is a bail application and records are also here. Oh, you are here. Familiar face from Guwahati. Okay. 1 second. 16. This is a BA. He is inside since?
Your Lordship, I'll just take some few minutes, Your Lordship. In the last occasion, we have stated that since there was an application before the magistrate for recording of the 183 of the victim, Your Lordship, which is not
For
183 of the victim, Your Lordship,
Hmm.
corresponding 164 of the victim, Your Lordship. It is not present in the CD. This CD is a updated CD, Your Lordship. If Your Lordship just give me a few days time to get an updated CD, Your Lordship.
So 164 of the victim is not there.
Not there in the CD.
There is a case record here. What is this?
It can contain DA 164, just show her. Oh, yes.
Again, ground of arrest.
Or you can charge sheet, Your Lordship. I deeply apologize. This.
Hmm. Suffering from? Hmm. Hmm. This is under what section? What is that? 64(1)? Huh? 376? Okay. Not minor. Hmm. Let me see whether that 164 is there.
It's there, Your Lordship. It's there in the.
It's there. Can you do it now or today, or you want some other day?
We can do it today. There is no issue, Your Lordship.
Okay. He has come from Guwahati.
Yes, on earlier occasion, that since the ground in the petition, though he made a submission with regard to ground of arrest, that was not there, Your Lordship. Then there was a suggestion from this honorable court to file an additional affidavit to bring in that contention averments that the issue also involved ground of arrest. That has been filed, Your Lordship.
Ground
Here
of
this
arrest,
matter.
that ground is not there. Okay. There is something. Vihan Kumar.
Yes.
Huh.
So
no, that is okay, but there is none. No ground of arrest at all.
it's there, Your Lordship, at page number 18, Your Lordship will see.
Again, that retrospective, prospective, those things will come. He was
The relevant is at page number 19. Your Lordship will see the column number 10. Reason as well as the ground of arrest.
where? 19.
Page number 19.
Reasons and grounds of arrest.
Yes.
But there is nothing.
It's there. Your Lordship will see the sub columns A, B, C, D, and E, Your Lordship. And the remarks are listed on there.
These are not grounds of arrest. Because Supreme Court has made a difference between prisons and grounds.
Yes. Even in that case, Your Lordship is referring to Purkaster case. Your Lordship. Yes, yes. Even in that case, Your Lordship, if you remember, you'll see that the reason in that memo of arrest warrant, Your Lordship, only reason was reflected, not the ground. Even in our case, Your Lordship, we'll see there is not only the reason but also the ground. The same are the ground for arrest.
Public grounds of arrest.
Yes, because in that case, only reason, the reflection was that the arrest memo contained only the reason of arrest and not the ground of arrest. However, this is, Your Lordship will see that we don't have a specific format of arrest memo. Even on our state, Your Lordship will see that on previous, this arrest memo was subsequent as the matters came around, and we have made a suggestions to the Department of Police that there need to be a ground of arrest and there has to be put in form of column. Otherwise, prior to that, only a simple memo used to be there, only name who was given notice and only the place of arrest, date of arrest.
Hmm.
These were not given. Only after these issues came into consideration before the court, Your Lordship, we had intimated the department, and that's when this format was subsequently made, Your Lordship.
No, okay, I'll see to that. Whether these are grounds of arrest, can you say these are grounds of arrest?
Yes, Your Lordship.
Prevent accused from committing any further offense?
Yes.
For proper investigation of the case, yes.
Yes.
To prevent the accused person from committing the
Yes.
evidence of to disappear. No, these are cannot be. On what grounds he has been
As
arrested?
unless
This
this
is what is.
person is arrested, his presence in the court whenever required cannot be ensured. Why more particularly this reason, Your Lordship, ground is because this accused was absconding, Your Lordship. We had traced his CDR, Your Lordship. We had approached the police of the Assam, Your Lordship, and that's when we could arrest him, Your Lordship. And therefore, particularly E, Your Lordship, unless this person is arrested, his presence in the court was not.
No, still these are not grounds. Grounds has to be why he was arrested. What is the offense? And what was the requirement? How is he involved? Those, whatever it is, but let me see the FIR.
Yes.
But one thing, this FIR was when?
It's a rape case, Your Lordship.
After so, it delayed FIR.
Delayed.
But okay, I'll go to the explanation. What about the, when was the? Acha. FIR was registered 6/1/2025.
Yes.
Because I think in the, there's one more decision now before Parvir Purkastra, which was the, where written grounds of arrest were directed to be given.
Your Lordship.
The before, Vihan came later. Before that, Parvir. Then, one before that, was there one, there was one?
Your Lordship,
Which was a known decision.
This too, I have two
Because
judgments.
because in that decision it is said, henceforth, written grounds of arrest has to be given.
Yeah, Your Lordship.
When was that decision and when is this FIR? I think it is before 25. That's 24.
It was because the latest.
That is there. 22(1) is there. 22(1) is there. Yes, those are there.
No, yes, I'm not denying to that.
But not in writing. In writing is a proposition given by the Supreme Court.
No.
Did the new decision come? Hit and run case?
No.
Because there, whether writing is mandatory or not, is no. It has referred to this. It was referred to a larger bench in hit and run case.
There is a citation, Your Lordship, of the Apex Court, which has till date, I've been following this matter, Your Lordship. Till date, there is no, the judgment was reserved. However,
that is what the hit and run case.
It's still in this, Your Lordship. The issue was that unlike any other special act and the IPC, should there be a written ground of arrest was the issue, Your Lordship. This case has been reserved, and even yesterday I have been looking after this, Your Lordship.
It has not been read.
25/11/2024 that it was
reserved.
No. The order was of 22/4/2025, Your Lordship. The hearing was concluded, judgment was reserved, however, till date.
Whatever it is, it will not bring everything to a halt.
Yes.
So let me go through the FIR. That my daughter, read it out, I am to inform. That was around 3 months back. Petitioner is Rajiv Das.
Rajiv Das is the accused.
Rajiv Das is taken. Okay, she has filed on his behalf. It's okay. After so and after playing futsal. Oh, this is football. Giri Langya. They know each other. Took her. Okay. Let it now. Heard Mr. Yes. Oh, it's not there. S. Rahman. S. Haq. Your name is there, Sahidul Haq. Yes. Mr. S. Haq for the petitioner, as well as Ms. T. Gini, the learned additional public prosecutor for the state. This is an application this is an application filed by the petitioner under section 483. Application filed by the petitioner under section 483 of the BNS, praying grant of bail to the accused person who was arrested on 21/3/2025. In connection with the Pauline P.S. case number 1 of 2025, registered under section 64(1) of the BNS. The allegation against the petitioner, not petitioner, the allegation against the accused person, who is the husband of the petitioner, is reflected in the FIR dated 6/1/2025. In the FIR, it is stated that on 9th of September 2024, at around 6 p.m., the accused person, who was a JCB operator, picked up the daughter of the informant from a shop in his vehicle and dropped her at What is this BD Marts futsal?
Futsal, Your Lordship will see the artificial ground where footballs are being played, Your Lordship. It's
Okay.
referred to as futsal, Your Lordship.
It's a kind of a stadium.
Not exactly a stadium, it's a playground, but the carpets are artificial in nature,
Okay.
Your Lordship. It's a small.
Okay. Dropped her at a playground. And when she was about to, and when she was on her back to her home, the accused persons was seen waiting for her, and he offered to drop her at her house. Full stop. The victim trusting him, went with him. However, the accused person.
This issue was dealt with on earlier 2 occasions by my brother Atar. Though there was lengthy argument on this, Your Lordship. However, the court, while passing an order, did not write any specification with regard to this ground, only on the merit of the case, Your Lordship. That's why I'm deeply obliged.
Thank you. And I'll give that judgment where it is said henceforth, but then it will not affect this case because that was 24. Deeply obliged. Yes. Let us, take care of the documents. I have the habit of keeping it here and there. So this is.
Lordship,
One second. This was also by PP, by Ginny. Item 15. This is for orders. Why? Acha. What was the last order? Await service report. What? FOXO?
No, Lordship, it's a Lordship, order, Lordship, of a CGM order which is upheld by the session court, Lordship.
Response number 2 is required.
Yes, 2 and 3, Lordship.
When did you take steps and all? Still awaited. Fresh steps? Will you take fresh steps now? Yes, yes. We have taken steps in January for the 3rd time. Take it through the OC.
It's also a concerned jurisdiction of the
Jurisdiction. Okay. Heard Mr. E. Menjo, Learned Counsel for the petitioner, and Hage, and Lakshmi Hage, the additional public prosecutor for the state of Arunachal Pradesh. It is seen from the, there is no office note. Yeah. It is seen from the office note dated 23/6/2025 that the report, that this report in respect of respondent number 2 has not been received. Since it is stated at bar that steps have been taken thrice for service of notice upon respondent number 2, the same is not served. As such, a prayer is made that the service of notice upon respondent number 2 may be routed through the officer in charge of the jurisdictional police station.
concerned jurisdiction also is coming district, SEPA PS, Lordship.
Okay. The prayer is allowed. But you have to serve the copy.
Yes, sir. But this would be for the office of public counsel.
No, so actually we only special cases only we have to do
No,
that.
this is actually in respect of POXO
Yes,
matter.
yes,
Now
Lordship.
that is different. So here, since it is not that, so it will be done by the registry through the so-and-so.
Yes,
Public
Lordship.
prosecutor office may not be ready. So a prayer is allowed. The petitioner to take steps for service of notice upon respondent number 2 through the jurisdictional.
2 and 3,
through the-
Lordship.
Huh?
2 and 3, Lordship.
2 and 3.
Yes,
What's
Lordship.
the 3? 3, it's no longer there, I think. 2, only 2 is awaited.
Okay, Lordship.
3 is served, I guess. Only 2. So through the officer in charge, which police station is
SEPA
that?
PS. SEPA PS is coming.
Semba, whatever is police station. Oh, you will not know, no? What you tell her? Okay. District, whatever. Coming to be routed through the registry. You give it to the registry and then we will to be routed through the registry. List it after 2 weeks.
Obliged.
Why is that come up for orders? Counter has not been filed. Has not taken steps. But then the office note shows that you have not taken steps. Two days. No, you take steps by 2 days, you give the copy and then, okay. The heard so-and-so for the petitioner as well as you for the.
I am for a respondent number 241.
This is a CRP, civil revision.
Yes.
Civil, you are for respondent number
One.
all three.
One.
Oh, heard so-and-so for respondent number 1. Acha, 2, 3 is not served, yes. 1. It is stated by Mr. What's that? Okay, we are harming in on behalf of K lawyer that the service upon respondent number 2 and 3. Oh, steps for service upon respondent number 2 and 3 was inadvertently could not be taken. He has such praise for some time. Steps. The prayer is allowed. The petitioner to take steps for service of notice upon respondent number 2 within a period of 3 days from today. Okay. List the matter after 2 weeks. Services complete.
Lordship, we have not received the petition copy.
Oh, okay, you serve him.
We have received only the notice.
No, it happens in Guwahati also, I've seen. Serve a copy. Okay. Sometimes what happens, the councils get changed and copy goes somewhere, it can happen. So, heard Mr. Saxena. Yes, Saxena. You come very often here, it seems. Okay, Saxena for the petitioner as well as?
Yes, Ram.
S. Ram. Yes, Ram for the sole respondent.
Yes, sole respondent.
For the sole respondent. It is stated by Mr. Saxena that the service that the pleadings are complete. Stated that the records are here as well as the service is also complete and the matter is ready for hearing. So admission hearing. Okay. As such, he has prayed the matter on 18th of August. The prayer is allowed. List the matter on 18th of August. 18th of August is okay. It's a Monday. M. Doji. Okay. Why has it come up? Service is not complete. How many respondents?
There is 5 respondents.
There are. Okay. One is served. Wakalatnama filed to enter a same is kept. Now, steps have not been taken. Take steps. Okay. Somehow mistakenly. Okay. Heard Mr. So-and-so on behalf of M. Doji. Your name is there in the cause list.
No.
Oh, you are appearing on behalf of Tea Time. Oh, so-and-so appearing on behalf of Tea Time. And Mr.
I'm respondent number 1, Your Lordship. K. Moses.
You are Mr.
K. Moses.
K. Moses, yes.
Yes, Your Lordship.
For respondent number 1. It is seen from the office note that steps for service of notice upon respondent number 2 to 6 have not been taken inadvertently. As such, the council appearing for the petitioner prays for some time to take steps. The prayer is allowed. The council for the petitioner is allowed. Petitioner of council is allowed 3 days time to take steps for service of notice upon 2 to 6. List the matter after 2 weeks.
Deeply obliged.
What was that? Acha. But the TCR is not received. Record is not here. But then it was called for, na? Yes. Call for the scan copy. When it is in the judicial order for the scan copy, let us wait for some time. Then next week it can be done if it comes. Otherwise, scan copy of the so-and-so is called for on 1st of May, 2025. Okay, so 23rd of July. By that time, I think scan copy will come. This is what you said? This. Oh, for quashing? Okay. But then since there is a judicial order, okay, heard Mr. Saxena, for the petitioners as well as Ginny, the learned additional public prosecutor. It is seen from the office note dated 3/6/2025 that the trial court records have not been received from the learned court of CJM Alo. A reminder may be issued for sending the records from the said court. List the matter after 3 weeks. You said a date. Okay, list the matter on 23rd of July, 2025, as prayed for by the counsel for the petition. Deep. Hearing at 4:15. But then you had come from Guwahati. You both have come from Guwahati. Acha. Right. But then 4:15 now hearing, see my predicament also after going through
this matter also needs some hearing.
So cannot be finished today. Due to paucity of time, the instant case could not be taken up for hearing. As prayed for by the council, list the matter on court. Decide on a date.
I will accommodate him since he came from outside. Only the thing on 4th, I have some engagement in other courts.
Okay. Take some other date.
Yeah, July.
Oh, there is vacation here. You take it on 23rd, 24th July? Okay. 12th August, is it okay for you?
Yes.
Fix it, list the matter on 12th August.
No. Here, Your Honor. This status quo was not continued. Not continued. Initially, it was given ad interim. After my appearance, this has not been continued.
No, it is continuing. See, the last order 7/1/25.
Not continued. Not continued.
Because the last time it was not continued, because they have prayed for time. Unfortunately, it was not continued. The order was
10/1/25.
Your Honor, my lord, that status quo order has not been continued. My lord can see it. This matter after hearing me, and this was not continued. So therefore, my lord, without hearing now status quo.
No, admittedly, I can see the orders The interim order is not continuing as of date.
Not.
Because it got discontinued, because last was on 7th of January, where it is said interim order shall continue till next date of listing.
Yes.
And the next date it did not continue. It was
Since then-
mistakenly. Hmm.
Last time also, they also made same prayer. That was not allowed. Before
But
that-
whatever, the stay was not.
Yes.
Hmm.
Exactly. 12
Uh-huh. Hmm.
They have to file an application under order 3904.
Hmm.
They did not prefer any. On this order basis, interim order cannot be discontinued.
Hmm.
It's a civil dispute. They have been under order 43, rule 1R, and one application has been preferred under order 39. And that, that application, the status quo order was being granted. For that, they have to file a proper application under order 3924 for revision of the status quo order. They did not file any application.
My submission, my lord.
No.
This honorable court, because status was granted till returnable. After this honorable court, in its own wisdom, after hearing me, if this honorable court has declined to extend the status quo, now what will happen, my lord? Since all earlier bench have declined, today it seems it will amount to something, my lord, again without hearing again.
But now I cannot give you
Yes,
that
yes,
status quo
that is
order
the thing.
because in between it got discontinued.
Yes. And every
Because
time,
it
every
was
time he
stated-
prayed, but that was declined.
Because it was returnable till it was made returnable till the next date.
Then subsequently, after first order 59,
Ah.
that was extended.
No, that was extended. That was extended on 5/9, that was 8/11, 28/11, 18/12.
Thereafter, they have prayed for time, and it was unfortunately the time was missed out.
Ah, that is what, it missed out.
Therefore, it doesn't.
No, this is wrong statement. Last occasion also he prayed after hearing.
No, last occasion, not happened.
It's okay, don't fight. But then problem is it got discontinued. How can
Yes,
we
yes.
give this status quo order now?
No.
Again, I'll have to hear.
Yes.
And again,
First, after hearing parties.
No.
it is okay. But it got discontinued. Mistakenly, nobody pointed out
And
while mentioning.
No mistake. My lord, this initial status quo was first ad initio. Thereafter, it was not discontinued. Thereafter, I appeared. I argued. Matter was heard. Thereafter, matter could not be disposed.
You're Mr. Shiladitya.
I am sure.
Oh, you're Shiladitya, yes.
Then matter was heard.
You're Mr. Khambo.
Arsonar.
Oh, Arsonar, yes.
Matter was heard. After hearing, my lord, this court declined to extend the inquiry.
Where is that?
No, that's why not extended.
No. It was not written. Had it been written, then no longer that. It was mistakenly left out.
Mistaken, my lord, if see all the orders, it is not mistakenly maybe for.
Acha, no. There is an order on 1812. See 1812 order. Our Sonar Largent Council submits that connected title suit has been dismissed for non-prosecution of the trial court. Vide order, he submits that status quo order operating in the present proceeding has caused prejudice to him. Right. However, considering that fact that prayer is made on held ground of the arguing counsel, this prayer that a matter be listed. It is provided no further adjournment. But still, there was no rejection. That is your submission. And again, there is an order, interim order passed earlier shall continue. That was in January. But after 10/1, it missed out. It
That
got
was not
away.
mistakenly. He repeatedly prayed. That was not allowed by this honorable court. The earlier presiding judge. That is there.
One thing you can do on the next date of hearing.
We can dispose this matter. Is ready.
Dispose this matter, but
No.
but then it got discontinued. How can I again
Yes.
give?
And my lord, admittedly, I am in the possession of the entire land. Title is with me, possession is with me. If we go on the merit of the case here, that is there.
But then there was a prayer that it is causing disturbance, right? The interim order, but then there is no finding.
There is no finding. There is no specific order.
But the fact remains, my lord, that he repeatedly prayed last occasion to 3 occasions, but that was interim was not extended. This is on. This is the fact.
But there is no
That it may not be-
stipulation.
But the record shows that it has not been extended.
It has not
This
been.
mistake can be for one time, Your Honor. For series of order, mistake cannot be there. Had it been the case, Your Honor, one time without paying mistake took place, we can understand.
On the
Repeatedly,
next
he-
day, let the matter be disposed of, let it remain like this.
Like this, for the interim order was first started.
Hmm.
And accordingly to the chairman, they will file an application for cancellation of the interim order as per order 39-4. Is it regular? After agreeing, we have filed.
They have not filed application. They have just made some oral submissions.
For cancel application, they are not doing application. This is order 39-4.
My learned
On
friend.
order basis cannot be.
That is how no order is
My lord,
passed.
my lord, it is something. Once my lord has passed one order, he'll return everything. So on the appearance of the other party, if he apprise certain fact, if after hearing the court doesn't want to extend it, where is there is something, there is no such.
No, don't go on that ground that they did not want to extend it. There is nothing on record. Can be a mistake on their part. They did not point out about the
This is
interim
not the
order.
mistake at all. Repeatedly they prayed. All occasion was, if the prayer was declared. This is what I'm saying. Had it been because.
Okay, whatever it is, let the matter be like this today due to paucity of time. But now.
Then you will repeat it,
Okay. Okay, fine. Last July, you take it on 23rd, 24th?
22nd,
24th?
22nd.
22nd. Okay. Place the matter on 22nd of July instead of.
Submission is that for cancellation of the status quo, there must be application.
Because of that, the court did not pass any order.
It's an implied matter because when under passed, sometimes it doesn't mean that the entire status order goes.
Okay, on the next day it will be heard.
Give your.
Okay. Matter, case is exhausted. Yes.